If you're testifying via Zoom, please keep yourself muted and your video off until you testify, and then turn it off again after your testimony. Use the Zoom chat function if you have technical issues. Our staff will try to help you out. If you're disconnected, it's okay, don't panic. Just try to rejoin as soon as you can on Zoom, and I'll try to fit you in so that you can finish your testimony if time permits. If the power goes off in the room here and we have to reschedule the hearing, I'll make sure to post appropriate notice so you all know what we're going to be talking about and when. If you're testifying on Zoom, please avoid using any trademarked or copyrighted images. That kicks us off of YouTube, and that's not good because we want the public to be able to watch what we're doing here. Please refrain from any profanity or uncivil behavior. It's okay to disagree, but let's not be disagreeable. We're all in this together, trying to do what's best for the state. So with that, let's go ahead and start the hearing. And just so everyone knows, we're going to be having testimony, taking testimony on all of the bills on the agenda, and we'll go all the way through all the bills. At the end of that, we'll then move into decision making on the bills in the order on which they appear on the agenda. So if you have to go off and do something else, you know, that's our schedule. That's how we'll manage today. So it is Wednesday, March 25th, 2 p.m. here in conference room 325 for our hearing on the committee, before the Committee on Judiciary and Hawaiian Affairs. First up, we have Senate Bill 3219, House Draft 1, proposing amendments to Article 7, Sections 12 and 13 of the Hawaii State Constitution. The measure proposes constitutional amendments to expressly provide that the legislature may authorize political subdivisions, such as the counties, to issue housing infrastructure growth bonds for specified public works, public improvements, or other actions necessary for housing and community development, and exclude these bonds from determinations of the funded debt of the political subdivisions. First up, we have Hawaii Public Housing Authority in support. Not present. Members, I refer you to the written testimony. Next, we have Hawaii Housing Finance and Development Corporation in support. Welcome, Mr. Minakami.
Good afternoon, Chair, Vice Chair, members. I'm Minakami, Executive Director of Hawaii Housing Finance and Development Corporation. We stand in our testimony in support of this measure. We anticipate that housing infrastructure growth bonds can be a valuable financing tool to facilitate transit-oriented development, and of course, TOD can help to address our housing shortfall. So thank you.
Thank you. And for everyone who's not familiar, TOD means transit-oriented development, like the nodes of development along the rail line or along bus lines where we have bus stops. Next, we have Mary Alice Evans with the State of Hawaii Office of Planning and Sustainable Development, or her representative.
Aloha, Chair, Vice Chair, member of the committee. Diana Setness with the Office of Planning and Sustainable Development. We do stand on a written testimony in support, but just to summarize, this will just essentially add another tool to the toolbox for infrastructure financing, something that is very much needed for any housing development in Hawaii. And we also noted that we previously preferred the companion measure, HB 2476, but in the previous committee, this bill was amended to essentially insert that language, and now the only difference is the exact phrasing of the ballot question, and we respectfully defer to the Attorney General for specifics on that.
Thank you very much.
Thank you.
Next person to say they wish to testify is the Pacific Resource Partnership.
Thank you, Chair Tarnas, Vice Chair Boy, Andrew Pereira with Pacific Resource Partnership. Stand in strong support of the measure with our written testimony, but I just want to add that we had another briefing with the financial advisement company, Stifel, and they said that a lot of municipalities that suffer natural disasters are not now using this type of value capture financing to rebuild infrastructure that's lost during a natural disaster. So this will be another great recovery tool. For example, the flooding that we just suffered in Lahaina with the wildfires. So stand in strong support. Thank you very much.
Thank you very much. Next, DR Horton, Hawaii. Mr. Iosua.
Good afternoon, Chair, committee members. Mike Iosua on behalf of DR Horton, Hawaii. You have a written testimony. Just wanted to add, everybody knows we're in a severe housing crisis right now. This is an important tool to kind of help offset some of the costs of infrastructure, which can be as high as 30% of the price of the house that you're paying. So happy to answer any questions.
Thank you very much, sir. Evan Oy, in support. Lindsay Garcia, Hawaii Hawaii Realtors or her representative.
Good afternoon, Chair, Vice Chair, members of the committee. Mihoko Ito on behalf of the Hawaii Association of Realtors. We stand on our testimony in support of this measure and are happy to answer any questions. And just wanted to note again that this is a very valuable tool to help support housing infrastructure, and 48 out of 50 states have already enacted something similar. Thank you.
Thank you very much. Tom Yamachika, Tax Foundation of Hawaii on Zoom.
Aloha, Colleen Taramai on behalf of Tom Yamachika. The Tax Foundation of Hawaii stands on its written comments. Thank you.
Thank you very much. Housing Hawaii's Future. Barry Aerosmith in support, not present. Sam Kim, Hawaii Regional Council of Carpenters. In support, not present. Is there anyone else wishing to testify on Senate Bill 3219? If not, questions, members? Seeing none, thank you. Well, thank you to the testifiers. We'll move on to the next measure. Senate Bill 2054, Senate Draft 2, House Draft 1, relating to public safety. This measure prohibits the Hawaii National Guard from deploying to assist federal troops, federal law enforcement, or the National Guard on any other state operating, prohibits the Hawaii National Guard from deploying to assist federal troops, federal law enforcement, or the National Guard of any other state operating in Hawaii when the governor has objected to the deployments. First up, we have Brigadier General Walter Ross, Hawaii National Guard in opposition, not present. Office of Hawaiian Affairs in support, not present. Community Alliance on Prisons, Ms. Brady.
Good afternoon, Chair Tornes, Vice Chair Poipoi, Representatives Cochran and Shimizu. Community Alliance on Prisons is in strong support of this measure. We're really proud that the governor has been very clear about using local resources for local issues. And we really urge you to support this bill. Thank you.
Thank you very much. Next, Austin Martin on Zoom. Go ahead, sir.
Thank you, Chair, and thank you, members of the committee. This is a proposal that, in its original form, included language that was more expansive than what we have today, but it's important, and it reinforces a concept where liberty is maximized, where the local people have the greatest amount of say over what happens. And I think actually, I just want to make myself available for any questions, and I think I'd like to stand on my written testimony. I'm sure you guys have had a chance to look it over. So thank you for hearing me today, and thank you for looking at this seriously.
Thank you very much, Mr. Martin. Next, ACLU of Hawaii. Mr. Frost.
Good afternoon, Chair, Vice Chair, committee members. I'm here in place of Mandy, who I'm sure you'd much rather prefer seeing. She wasn't able to attend this afternoon, and honestly, I wasn't prepared to speak on it. We stand in strong support of the bill. You have a written testimony. You know, in Hawaii and across the country, we've seen federal agents taking immigrant neighbors. Immigration enforcement has spiked since the beginning of the current administration. And we've seen this administration attempt to deploy National Guard in cities, frankly, that he doesn't like. So this bill, we believe, makes an attempt to minimize that or make it harder to do that. Again, I wasn't prepared to speak. So, but you have our testimony. We're in support, and we hope you move the bill forward.
Thank you very much. Liza Ryan Gill, Hawaii Coalition for Immigrant Rights on Zoom.
Aloha, Chair, Vice Chair, members of the committee. Liza with Hawaii Coalition for Immigrant Rights, representing about 30 immigrant-serving organizations across the Pai'aina. We're in strong support of this bill, and I'll just say, just to put a finer point on it right now, we are seeing, our local National Guard being deployed across the state to help folks in the recovery from the Kona low. And because of the expansion of Department of Homeland Security, bringing in other federal agencies and even deploying to 14 airports across the country right now, taking on some of the responsibilities of TSA. What that has created is just a lot of confusion as to who is who. And we've been receiving reports, screenshots of National Guard individuals in Humvees going through Kalihi, and that has created fear in different communities that are immigrant communities that may have come from places where there have been martial law and they've experienced military vehicles running through their residential neighborhoods. If I'm very sympathetic to the concerns of both Haima and other folks maybe within the National Guard over the command issues on this. I think what we hope to see is that in all of these areas, we want to make sure that our resources are being used to serve the people of Hawaii first and foremost, and that the concerns of individuals who don't know which agents have what kind of kuleana and what they're doing in their community, that we can speak very clearly as to what those roles are. So mahalo for your time.
Thank you very much, Ms. Gill. Next, Christine Andrews on Zoom.
Aloha Chair, Vice Chair, members of the committee. Christine Andrews, Maui. I'll stand on my written testimony, but I do want to just reiterate that for the people of Maui, we have had a good relationship with the National Guard. The community trusts them based on their assistance with disaster relief, especially after the wildfires. And we really think it is important to maintain, again, that role of the National Guard coming here to help our community. And if they were to be engaged by the federal government over the objections of our governor, that would interfere with that relationship. So we really are trying to ensure that the people of our community serve our community, and we delineate the lines with the federal government clearly. Thank you so much.
Thank you very much. We've received 49 testimonies in support, 4 in opposition, 1 with comments. But that's all who said they would want to provide oral testimony. Is there anyone else wishing to provide testimony on Senate Bill 2054? In the room? On Zoom? If not, questions, members? If not, we'll move on.
Sorry,
Thank you.
Chair.
Rep. Cochran?
I know ACLU, you open for questions?
You could also ask Ms. Gill, Liza Ryan Gill, who is on Zoom.
She might. You can ask me, I can't promise an answer.
Okay, is that?
If you are interested in immigration law, it might be better to ask Ms. Gill. No offense.
No, not so much immigration.
Okay.
So this is, because you're in support, and
Yes.
I'm just wondering if you have any take on, the position of the National Guard themselves. Are you supporting that this isn't interfering in their, actions, to what their clear responsibilities are?
So this is what I can say, so our policy director, as I understand, sent an email earlier today, and I'll just read what I think she sent it to everyone, but just in case. So what she says is, Newsom v. Trump doesn't speak to the question about the bill. Whether it's already an authority the governor has here is a question of state law. SB 2054 is still very strong and doesn't require amendments. It pertains to National Guard in state of active duty or Title 32 status, not federalized National Guard as was the case in California.
If maybe I could suggest that.
Sorry, I can't.
Since Liza Ryan Gill had actually spoken in her testimony about the concern of the command structure and the potential conflict,
Okay.
perhaps you could address your question to Ms. Gill.
That sounds great, Chair. Thank you for that opportunity.
Sorry.
Not a problem, thank you. Hi.
Aloha.
Yeah, I just, a little more elaboration, I suppose, because I'm hearing what the National Guard, was saying, and, this is for outside, forces coming in. Is that kind of what it's trying to address too, though? Is that your understanding at all? And
Go ahead, Ms. Gill.
Yeah, our understanding in other jurisdictions and other states where the federal administration has gone over the head of the local governor to send in National Guard forces against their wishes. Now, we've seen that We saw that in Los Angeles and California and in other instances. And I believe I was just quickly perusing, and I've been at all of these hearings to hear directly from some of the National Guard commanders. I think that it's obviously a very awkward situation. They haven't been put in this kind of role before where they have to be concerned about what the command structure is and who they should be listening to on this front. And so I am sympathetic to that because all of this is very weird and a difficult time to navigate. I do think it is important, given that we have experienced multiple disasters where we have FEMA, we have our own National Guard, we have others coming in. We don't want to be in a situation where we're very vulnerable as a state because of a disaster, and that vulnerability is used against us, wherein we are bringing in, maybe we need to bring in some support from the continent, be it FEMA or another federal agency, and then that agency then is used against us in ways that our governor has not condoned. So I don't know if that helps you answer your question. This is honestly a pretty tricky needle to thread, but I think given what the judgments that we have seen out of California, that we still have the right to be able to move forward and make sure that our governor has this authority to decline the use of National Guard against his desires.
And one follow-up,
Right.
please, Chair. Thank you, and thank you for those comments. So there's a portion that says prohibits National Guard from assisting or cooperating with federal troops. Would this include just our own military people that are here on our island? Because they're federal employees, right? They're federal troops, actually, right?
If
So
I may
would that
just clarify,
interfere with that?
if I may clarify up for all members, that this measure is specifically related to the occasion when the governor has objected to the deployment of the National Guard. But the president, as we've seen in another state, has overruled and sent and deployed National Guard into the state where the governor has objected to it. So that's what this bill deals with, just so you know.
Alright, okay.
Awkward situation at best.
Yeah, I have an answer, but yeah, thank you for your time and thank you,
Thank you, Ms. Gill.
Chair.
Appreciate it.
Any other questions, members? Okay. Thank you to all the testifiers on this measure. Let's move on to the next measure. Senate Bill 2688, Senate Draft 1, relating to compassionate release. This measure establishes a protocol for compassionate release for certain ill or seriously debilitated incarcerated persons, and it appropriates funds. First up, we have the Crime Victim Compensation Commission.
Good afternoon, Chair, Vice Chair, members. Pam Ferguson-Gray, I'm the Executive Director of the Crime Victim Compensation Commission. Our commission has represented the interests and concerns of victims and survivors in the number of penal code review committees, the Justice Reinvestment Initiative, among other things. The criminal justice reform, we believe, must not only serve the interests of the offender, but must also include meaningful protection for the interests of crime victims. Our comments actually are opposed to the bill. I'll clarify that by sending additional updated testimony. We believe the bill does not meaningfully protect the rights of crime victims because no notice to victims is provided to them until after there's a release decision. The bill only provides notice after the offender has been released, unlike the draft that's in the Senate right now. So victims have no opportunity to provide input regarding the release decisions, and failure to provide this information to the paroling authority actually deprives them of the ability to make a meaningful decision about whether or not the person represents a risk to the community safety of a particular victim. It deprives victims of their ability to create a safety plan in a timely manner, and it deprives the HPA of information needed to craft release conditions that would be necessary to safeguard the safety of the victim. In addition, the working group does not have a representative from the crime victim community to represent the interests of victims in creating the administrative rules. So those two things, we oppose the bill as a result of those. There's a lot of information from the National Council of State Legislators about how to craft meaningful proposals that do protect crime victims and medical release. Additionally, there's a compilation from the National Crime Victim Law Institute of every state, how they handle this and how they make sure that victims receive notice, have an opportunity to be heard, and can be protected with compassionate release decisions. Thank you very much.
Thank you very much, Ms. Ferguson Bray. Next, Hawaii Paroling Authority. Sir. Welcome, Mr. DeMello.
Hi, good afternoon, Chair, Vice Chair, and members. So the Paroling Authority offers comments.
Introduce yourself, would you?
I'm sorry, Gene DeMello Jr., I'm the Paroling Authority Chairman.
Thank you.
The Paroling Authority offers comments and has a suggested amendment to Section I. And that deals with the eligibility of the person sentenced to mandatory minimum terms of imprisonment, which we would like to see them serve that full term. And it also addresses life with parole in the bill. Those would be the amendments.
Thank you very much. Next, Department of Corrections and Rehabilitation. Director Johnson, welcome.
Good afternoon, Chair, Vice Chair, members of the committee. I'll summarize my testimony. We oppose this measure, specifically Section 2, for 4 different reasons. The first reason is we do not believe that people who are serving life without the possibility of parole should be eligible for compassionate release because their sentence hasn't been commuted by the governor and HPA hadn't had a chance to set a minimum sentence in hearing. We also believe that people serving mandatory minimum terms of imprisonment shouldn't be eligible because the court required them to serve a mandatory minimum term. The third thing is we believe that another inmate should not be allowed to assist another incarcerated person with applying because we believe there's an opportunity for issues with fraud. And at the same time, that inmate would have to have written release from the person to know about the person's medical care and condition. So there are federal and state HIPAA concerns with that. And then the fourth issue concern we have with the bill is that it does not take into consideration the nature of the offenses that these people committed. So I provided with our testimony, real quickly, a graph indicating that of the 20 people serving life without the possibility of parole, they've committed 101 crimes, which is 5.5 crimes apiece. And all of those crimes were either rape, murder, kidnapping, and in a few cases, they have committed more than one murder and more than one rape. For those reasons, we oppose this measure. Thank you.
Thank you very much. Next, Office of Hawaiian Affairs.
Aloha Chair, Vice Chair, members of the committee, McKenna Woodward on behalf of the Office of Hawaiian Affairs in support of this measure. OHA supports establishing a clear, fair, and timely compassionate release process because continued confinement should not become a substitute for appropriate medical care when incarceration no longer serves a meaningful public safety purpose. This issue matters deeply for Native Hawaiian beneficiaries because Native Hawaiians are disproportionately impacted at multiple points in the criminal legal system. So overly punitive policies and delayed medical release fall harder on Native Hawaiian ohana. OHA supports the SD1 changes, strengthening victim and prosecutorial notification and providing implementation resources because clear procedures, transparency, and coordination are important to public trust and effective administration. OHA's key concern is that SD1 narrows eligibility too much by limiting consideration only to people with a terminal illness or those too ill or cognitively impaired to participate in rehabilitation, and by categorically excluding people serving life without parole. Compassionate release has proven to work best when decision makers can conduct individualized medical and humanitarian assessments rather than relying on rigid exclusions that may block relief even where continued incarceration no longer serves a meaningful public safety interest. This bill is still important because Hawaii has historically relied on internal policy rather than clear statute in this area, and a time-bound statutory process is a major step toward more fair, transparent, and consistent decision-making. Mahalo for the opportunity to testify. We respectfully urge the committee to pass this measure with amendments addressing the narrowed eligibility provisions. Mahalo.
Thank you very much. Next, we have the Attorney General.
Good afternoon, Chair Tonners, Chair Portboy, and members of the committee. My name is Lisa Tamar, Deputy Attorney General. We offer comments on this bill. Basically, although we support the intent of the bill, we want to balance the compassion for the inmates with concerns for the risks and safety of the community. We offer amendments to narrow the eligibility of certain medical conditions. For example, narrowing the definition of terminal illness, debilitating conditions. We also ask that the committee consider allowing or ensuring that the HPA continues to have discretion on whether to release a person on compassionate release. We have to understand that there is already a process by which the HPA sets minimums.
Just so everyone knows, HPA is the Hawaii Paroling Authority.
I'm sorry, yeah.
It's okay.
So this process that the bill sets up bypasses the HPA's judgment that has already set a minimum for certain inmates. And for other inmates who already have mandatory minimum terms, the court has already set a certain period of imprisonment upon which the person is not to be released. So you're setting up a process by which that judgment, that decision is bypassed solely on the basis of what you define as terminal illness or a debilitating condition. So we ask that the compassion for that individual be balanced with concerns for the risks to the safety of the community. That's all, Your Honor. We also have the suggested amendments in our testimony. Thank you.
Thank you very much. Next, the Hawaii Correctional System Oversight Commission. Ms. Johnson, welcome.
Hi. Aloha, Chair, Vice Chair, members of the committee. My name is Kristen Johnson. I'm the Oversight Coordinator of the Hawaii Correctional System Oversight Commission. The commission stands with this written testimony, submitting comments. The commission did submit a fair amount of amendments for this particular measure, but I really wanted to focus back on the purpose of the bill. This bill is called Compassionate Release because it really focuses on the compassion of those who are sick and dying and suffering within our correctional system. The commission has the very unique access where we can enter a correctional facility at any time. We can go anywhere where we need to go. And when I go to Halava, I always make sure that I go into the infirmary, and I do that because I think it's important to see I think it's important to see the most amount of suffering that's happening in our system. These people take up an incredible amount of staff resources that the department currently does not have. When we talk to medical staff, when we talk to corrections staff, you know, these folks, you know, between the amount of care that they need to receive, what ends up happening is that the general population who also needs care end up being kind of pushed to the side because we really have to focus on the people who are just debilitated. The last point I wanted to offer is the cost. I think sometimes members of the community or different people forget that the state is paying out of pocket for every single person who is in our correctional system. There's no such thing as insurance once you're incarcerated. And so, you know, getting these people into the community, into more appropriate care also shifts that cost to the federal government, which would of course help the department and help the state. So I think that about wraps it up. I'm more than happy to answer any questions, but thank you for the opportunity to testify.
Thank you very much, Ms. Johnson. Haley Cheng, Office of the Public Defender. Welcome, please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. I am Haley Cheng. I am the First Deputy of the State of Hawaii Office of the Public Defender. We have submitted comments on this measure with some proposed changes. We have appeared before many committees through this session emphasizing the critical need for a formal compassionate release system. And I do want to highlight for those who may be listening or curious about what compassionate release is, this is not for someone who may have a minor illness or somebody who is slightly suffering. These are truly for the most debilitated, terminal, or impaired that need to be considered for compassionate release. I also want to highlight in response to some of the comments made earlier that there is absolutely going to be discretion retained by the Hawaii Paroling Authority. They still have to go through the application process. Certain criteria must be met. I would also like to highlight that if compassionate release is granted, that it is not just outright release. It is very similar to conditions of parole. You will be monitored, you will be supervised, and if you violate those conditions, you can be brought back and re-incarcerated. So I do just want to highlight that. Two of the sections that we mainly had comments about was the medical eligibility criteria. This draft of the bill takes away criteria described as debilitating or irreversible. It also removes a condition or a combination of conditions where the medical needs exceeds the capacity of the Department of Corrections and Rehabilitation, and we believe those should be put back in. There is another measure in front of the legislature, HB 1628 HD2, which includes that language, and we'd ask this committee to consider reincorporating that. We also submitted comments on the sentencing criteria, and that we believe that this version of the bill actually excludes those serving life without parole. And we've articulated all of the reasons why we believe that's important. We'd ask that this committee consider reinserting that language. Thank you so much for the opportunity to comment, and I will be available for questions.
Thank you, Ms. Chang. Next, Kat Brady, Community Alliance on Prisons.
Good afternoon again, committee. We're in strong support of this measure, although we really do like the House bill better, 1628. I want to underscore that this is a very, very, very small number of people who don't even know where they are. They're unable to participate in anything. Many of them can't even get out of bed. We work directly with people who are incarcerated, and many of them have actually been medical aids to people who are suffering. And I can't tell you the compassion they show to people. Unfortunately, the department only looks at why the persons were incarcerated. They don't look at them as human beings who are suffering from a whole variety of illnesses. There was a man in Halava who had neuroblastoma, which is a deadly form of cancer. And it's like the department can't support that. They can't, they know, they've said that we don't know how to care for these folks. So I think we need to understand what compassion is about. We have an Aloha Spirit law, and we need to start really thinking about that. It's not what the person did to get there, but where the person is now. And, you know, one person's medical care costs $2 million in, 3 months. And another one, their medication costs $900,000. And right after that, I was getting calls from families who were saying, my son, my daughter can't get medication. The medication's been cut off. There's no budget for it. So understand that everybody suffers. And we need to really look at this intelligently and humanely and realize that there are some people who are just so far gone. I've been a caregiver to many people, and I can tell you it is heart-wrenching, and it's something that never, ever leaves you. So I ask for your compassion and to perhaps substitute the contents of 1628 in this bill. Thank you.
Thank you very much, Ms. Brady. Next, Lou Erdicek, Hawaii Disability Rights Center on Zoom, not present. Support. Next, Molly Crane on Zoom. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you so much for the opportunity to testify today about this measure relating to compassionate release. My name is Molly Crane, and I'm an attorney at FAM. We are a nonprofit, nonpartisan organization, and we've worked on compassionate release for 25 years in every state and in the federal system. We are grateful to have collaborated closely with agencies, with family members, with people incarcerated and staff in this measure. We are providing comments today. While we wholeheartedly support the intent of this bill, without these following amendments, the bill will not align with best practices and will fail to achieve its cost and burdens shifting purposes. As we know, compassionate release is best practice that exists in the federal system and every state but one, because lawmakers recognize that people who are critically ill are the most expensive to incarcerate, the most burdensome to care for, and the least likely to recidivate. Although my written testimony discusses the features and importance of this bill in depth, I'll just briefly cover the 2 amendments we respectfully request. The first is to restore all categories of medical eligibility. The medical criteria in the original bill matches the Department of Corrections' already existing policies and procedures. Allowing only those who are terminally ill or so impaired as to be unaware of punishment puts Hawaii behind nearly every state in the country. These categories alone will not alleviate the extensive care burden on staff and will put compassionate release in Hawaii in a worse position than we are right now. The second is to restore all categories of sentence length eligibility. People serving mandatory minimums and people serving LWAP are eligible for compassionate release in the majority of parole-based states. This includes states across the political spectrum and across geography. And this bill allows for careful consideration of an individual's specific risk to public safety. We've seen across the country that programs fail to achieve their purpose in decreasing the burden on staff when they categorically restrict who's eligible. We provided cost estimates in our written testimony. Without these 2 amendments, the bill will not fulfill its fiscal responsibility aims. With these amendments, the bill will align with best practices and can make Hawaii a leader in compassionate release. We thank you so much for the opportunity to testify, and we respectfully urge you to pass the bill with amendments. This will reduce costs, support staff, provide dignity, and protect public safety. I'll be here for questions.
Thank you very much. Mr. Dennis Dunn on Zoom.
Good afternoon, Chair Tarnas, Vice Chair Poi Poi, members of the committee. Dennis Dunn's testifying in opposition to this measure. Let me make it clear up front. I am not opposed to compassionate release. There is a process already to do this. And I have some concerns, although I'd like to see some amendments that would provide notification to victims. I'm concerned that the compassionate release process itself may be unduly restricted by putting this into legislation instead of putting the discretion in the hands of the paroling authority where it belongs. So first of all, my first concern is that there's no provision for the consideration of victims in this process. As referenced, a lot of other states have legislation on this. Virtually all of them have advanced notification to victims, some as much as 30 days. And I think that some type of advance release is important. Secondly, I think it's important to note that consulting with victims in advance can result in a more appropriate placement. Placements that might be in proximity to the victim or even place them with other family members could be an additional risk that could be avoided when victims are consulted in advance. Also, I share the concerns that have been expressed by others that there may be conflicts here between existing laws regarding mandatory minimums and so on and the parole procedures, and I think those need to be resolved. Although victim notification is included in the current language, there's nothing specifying the way it is to take place, who does the notification, and the time frame. And then lastly, as mentioned by the Crime Victim Compensation Commission, the proposed working group, as so often is the case, does not include any members who represent or have experience representing the interest of crime victims, which make me assume that the proposed administrative rules emanating from the working group are unlikely to include the accommodations for victims that I'm suggesting. Thank you. It may be possible to amend this measure to address some of these concerns, but as it currently stands, I am opposed. Thank you for your time and consideration.
Thank you very much, Mr. Dunn. Next, Bob Merce. Welcome, sir.
Thank you, Chair Tarnas, members of the committee. My name is Bob Merce. Just a couple of comments. Number one, I think the ideal would be to get this bill congruent with House Bill 1628, and the two should be exactly the same, because the 1628, which has already passed this committee, reflect best practices. And as Molly Crane said, if it passes, it will make Hawaii one of the best states in the country for compassionate release, instead of one of the only states in the country that don't even have a compassionate release. I'd like to also say that I have never seen any law that says that granting compassionate release to somebody who's serving life without parole would interfere with the governor's authority to commute and issue pardons. I would also like to comment that I don't understand why one inmate can't help another inmate. I think if we're really focused on rehabilitation, that's something we would want to encourage. I've been out to the prison and I've talked to the men who are working in the infirmary and are cleaning up all of the mess that these men make, who are dying. But they can't help them apply for compassionate release. They can clean their bed, they can wipe their feces off the wall, as one man told me he did, but you can't talk to him about compassionate release and let him help him get compassionate release, even if he doesn't read or write, because this is what we're facing. This is a practical matter. I'd also like to say that, we have a legal obligation under Sling Law versus State of Hawaii to provide the people who are incarcerated with exactly the same standard of care as they would get on the outside, and we cannot do that because we don't have a hospital, we don't have a nursing home, we don't have a long care facility. We have an infirmary, the lowest level of care facility that there is, and they cannot take care of people who are there now, people who have brain injuries, brain cancer, liver cancer, you name it, Alzheimer's. They're in terrible condition, and that applies to people with life without parole. We have a gentleman right now with life without parole who's in the infirmary, and he is not getting the care that he should because he is dying, and putting him in a cell to die and just leaving him there and providing him with minimal care is not the way, it's not the way the law envisions that we will handle these matters. So I think some of the people who are talking about narrowing our compassion are just exactly on the wrong track. We need to expand our compassion because we don't have enough of it. And if you go out there and look at what's happening in the prison, you will see that we don't have enough of it. Thank you.
Thank you, Mr. Merce. And finally, Carrie Ann Shirota.
Aloha Chair, Vice Chair, and members of the committee, Carrie Ann Shirota. I'm offering comments. I absolutely support compassionate release for moral, ethical reasons because it reflects our value. It's also a best practice and it will save us money. But I'm asking this committee to incorporate amendments from the House Bill, HD2, into this measure. And I just want to address a few of the points that I've heard today. Number one, compassionate release, we're using that terminology, but in a number of other states and our own policies, procedures, we call it medical release. And as Bob has pointed out, an attorney, there's a state case law directly on point. There's also a US Supreme Court decision in 1976, Estelle versus Galloway, which states that states that incarcerate people have a legal duty to provide a standard medical care. If they fail to do so, they violate the 8th Amendment, cruel and unusual punishment. So there's both federal and state case law supporting the state has a duty to provide a level of care. And if they fail to do so, the state can be liable, but also the doctors and staff can be held personally liable. And I know that the doctors and medical team here are working as hard as they can, they're short-staffed. We don't want to put them in that situation. Second, we want to expand eligibility criteria for all persons because it reflects our values of compassion and aloha. Even individuals who have been listed and put in the spreadsheet of heinous crimes. For many of us, we're from faith traditions, we believe in compassion and people have the opportunity to transfer their lives. But beyond that, there could be individuals in there that we're making judgment upon who have been wrongfully convicted. And there are people who have been wrongfully convicted and who have died without any compensation from the state. So I think we need to remember that. The carve-outs, the Attorney General spoke today, provided comments. They did not provide, nor did they say that there's any constitutional violation by allowing this measure to go through and allowing HPA the authority to release individuals with mandatory minimums or people sentenced to life without the possibility of parole. There's been no case law, no treaties, nothing to support. That's merely conjecture. This decision is also medical. It's not any one of us making this determination. There are trained medical providers and staff who determine whether a person is meeting this eligibility criteria. And then in turn, the HPA Paroling Authority considers that, and they have the discretion if they believe a person is not ill. If you were to go into Halawa Infirmary, or to hear or even see some of the people who are maybe at Polimomi or the hospital, these people are gravely ill. They are not a threat to anyone. And you need seeing is believing. I also want to add that there's significant cost savings. I've heard from victims' rights groups, survivors. This bill has allowed for notification, which is a custom that's currently in place between Hawaii Paroling Authority and prosecutors, which Tommy Johnson stated directly. So we support that. But I also want to say, by all of the cost savings in this bill, that money can be used for rehabilitation. That cost savings can be used to support victims. And so we need to start looking at what really creates safety for all of us. And something that's missing in all of this, because we're focused on saying that certain people may not be eligible, are the families. There was a letter submitted by Charla Manuel from Hawaii Island. I don't know if she was able to tap in. She talks about her brother who was dying at Halawa. He served 30 years. He was on his way out. He got COVID. Please read her testimony. There's people with glioblastoma, brain cancer, all of these conditions. When you deny that person compassionate release, you're denying their ohana, the ability to have time together and closure. And that is devastating for family members. So please think about them. And last, I just want to add, looked at research in other states. In all 49 states, listening to hearings, others looked at reading testimony and more. Of all the states where this information was available, nearly every Department of Corrections was either neutral or in strong support of compassionate release legislation. And so I humbly ask that we embrace best practices and that we pass this measure. Thank you.
Thank you very much. Is there anyone else wishing to testify on Senate Bill 2688? Mr. Rust.
Apologies, I thought I submitted testimony. I can send it to everyone this afternoon. The ACLU stands in support of this. All the other supporters have basically said it all. I just wanted to highlight that Hawaii is the only state that has no statute that speaks to compassionate release. And also we support the amendments requested by OHA and the Oversight Commission. So we hope you make those amendments and move the bill. Mahalo.
Thank you. If you would submit your testimony.
Yeah, absolutely.
Anyone else wishing to testify in this measure? Yes?
Good afternoon, ladies and gentlemen. My name is Mrs. Susan Mahiai, and I'm going to share on behalf of the Compassionate Law. So supposedly my daughter is the little girl that got shot in her head. Her name is Richiana de Guzman, and this was almost 3 years ago, right? We haven't had any support. They had a suspect, but no more enough evidence to prosecute. But see, ladies and gentlemen, it's okay. Me and my family had the compassion to forgive this person, even if he's not in jail today, yeah? You know, on this island, we have a lot of evil fighting evil. Today, I choose to fight evil with love and compassion and forgiveness. You know, this guy is still out there, but it's okay, because I don't wish him going jail. I wish him doing the best thing, which is staying out of trouble and stop hurting people. There's a lot of guys in prison today, yeah? And they've been in there for many of years. A lot of these prisoners are sick, yeah? Sick with internal diseases, from HIV to cancer, to just being old. We gotta have the compassion, family, to let these guys out and stop using our taxpayers' money to fund and take care of these people. There's families out there that's willing, that has the willingness to want to take care of these guys. We got to have this compassion law passed, family. It's okay to forgive today, yeah? This place, I think, would be a much nicer place to live in if we had love and compassion. My daughter today is still out there struggling, but it's okay. I choose to embrace the pain and the struggle. It's okay because she's alive today. I have compassion for this person or persons that did this to my daughter. I came out of my way to come here to support this bill. We gotta stop locking these guys up like they animals, because really, they not. They just need love and they need the compassion to know that we care about them. Yes, they have did something really bad. Nobody is saying that they didn't. But as years went by, as they continue to get old in there, come on, family, we know they thinking, you know they did wrong. They know they did wrong. They're not gonna come outside be reckless again. They need that second chance to know that we care. We can. We have enough faith in them that they're going to change and they're going to be one. They're going to be something good in this community. Let's stop being, that problem. Let's get into the solution to that. And start forgiving and stop being compassionate. From what I heard on this island, this is the only island that does not have the compassionate law. Why? Why? Why we cannot be forgiving and loving? We just had one flood, guys. We had plenty people in danger of losing their lives. Let's start being more compassionate and start loving each other. Stop the fighting. Stop the locking up and putting these prisoners like they're animals in there, because they're not. They're not. They need people like us that care, that has the willingness to give them a chance to change. And I'm sure they're going to be one of those good citizens out there, helping those that's in need of help. We got to continue to be the light in these people's darkness. And that's what I am today. I'm this light that's in the darkness. My daughter is coming along, and that's because I choose to forgive. I choose to have compassion. I know I don't wish no harm on this person. No harm. No victim advocate. Nobody is helping us. Nobody. And it's okay. Because today in my life, I get God, And I know there's a lot of people out there that have compassionate and love for us. Even if it's just a hello, even if it's just a hug, that's good enough for me. You cannot put $1 family on compassion. There's no way. You cannot. And I'm going to stand with this law, and I'm going to fight for this law, because I feel we need to have more love, more forgiveness, and more compassion on this island, because that's what we are. We are Aloha. We're the Aloha State. Let's start standing up for the Aloha State. With that said, I love each and every one of you folks, and I'm all for this law. Thank you.
Mahalo. Sister, if you could
Yes, sir.
give your name to come on over there, just so we can keep track of who testified.
Yes, sir.
I appreciate you coming in to give your testimony.
Thank you for having me.
Thank you. Anyone else wishing to testify on this measure? Brother, you coming up? Okay. Please introduce yourself.
Good afternoon, everyone.
Afternoon.
My name is Matthew Taufete. I'm the executive director and founder of an organization called the First Lap. LAP is an acronym for Life After Prison. So I've been housing and mentoring men coming out of prison for 24 years now. With no government funding. So when we talk about this thing called compassion, I support this bill. Because I understand today, with Governor Josh Green declaring our state as a trauma-informed state, that's been my passion for years of understanding trauma. So for a lot of guys, they come out, they commit the crimes due to the trauma that they experience at home. So being able to understand that allowed me to have more compassion for a lot of these men and better serve them. 37 plus years, I took a person's life. And since coming out of prison, I was able to turn my life around. I found Jesus in my life. Ever since then, God just used me in mighty ways to go back into our communities, to help them to understand what forgiveness can do. In 2016, I became part of the HCR, the task force, appointed by Governor Ige. Got to understand, they visited our organization and they were amazed to see how I managed it all these years with no government funding. That way we can use the funds to support other organizations that might need the money. So having this compassion for these people. So anyway, I committed a crime. I got out, turned my life around, and working with gang members, trying to prevent them from getting to the gang. I was invited to go and speak at Annex 1 to all the gang affiliate members. not knowing, the pastor not even knowing my story. I shared my story, and sitting in the front row was the man who took my brother's life. So he was in tears, came out, hugged me. You know, ever since then, I became one of his mentors. He became my speaker at Waiava Corrections, you know, in 2024, and finally got released, you know, to a treatment program on the outside. I was just with him last night at an AA meeting. So we talk about having compassion for one another. It's through the power of forgiveness. So I hope we can support this bill to help a lot of our guys spend the last days with their family. So with that, thank you.
Thank you very much, sir. And if you could provide your name to Kamana, that'd be great. Thank you. Is anyone else wishing to testify on this measure? If not, questions, members? If not,
Question, Chair.
Rep. Shimizu, do you have a question?
I do, thank
Please proceed.
you. Director Johnson, please. Director, thank you for being here. Thank you for what you do. You have a very tough job. I have all the respect for you, and you know, I support this bill. I don't understand, based on testimony that we heard from the Oversight Commission, Kat Brady, Office of the Public Defender, all the positive things of what this bill accomplishes and addresses a problem that I'm hearing about, where there are inmates, that are dying and they're beyond care. I would think that you in your position that is short of staff, that is not able to take care of these people, that is short of funding, that will save so much money, not that money is more important than the person. I'm just wondering why you wouldn't be behind this bill.
Okay, we're not against, the Department of Corrections and Rehabilitation is not against compassionate release. If you recall, we believe that two categories of offenders that are listed in the bill should not be considered. And those are the people serving life without the possibility of parole, and those that are serving any unexpired portion of a court-ordered mandatory minimum term. Everyone else who qualifies, we support that. We just don't believe those two categories of offenders should be considered. One thing that's not mentioned is that whenever we send someone out for specialized care, and they're out of the facility overnight, we're reimbursed by the federal government. So the issue of the $2 million and $900,000 is bogus. We're reimbursed by the federal government for those funds that are expended. Now, we have to initially expend the funds, but those funds are reimbursed back to us. Again, we're not against compassionate release. When I was the administrator for HPA, I set up those expedited processes for compassionate release with the prosecutors and working with the Department of Public Safety at the time. It's just those two categories of offenders, that's all. Just those two.
Okay. Thank you. Thank you, Director Johnson. Thank you, Rep. Shimizu.
Sure.
Yes,
For
Rep.
Mr.
Cochran?
Johnson, hi.
Sure.
Thanks, and I heard you, and I too support it. And so the two categories, even though, I mean, they're, you know, terminal illnesses, they're just cognitively not there anymore, they're whatever, you know, bedridden, I mean, they're not gonna come out and, you know, create crime again. I mean, it's just clearly they're just not, you know, I mean, I'm just thinking back at my mom at her, so, I mean, there's already, you know, that, I mean, are you still really adamant that even as heinous as a crime is that a person had committed, even if they're in that condition, that physical, mental condition, you still are really, really like, no way?
That is the position of the department, but I think if you ask the Hawaii Paroling Authority, they'll give you examples of people who released on compassionate release who simply would not follow the terms and conditions of parole and who told the Hawaii Paroling Authority they have nothing to lose.
So, okay,
Okay.
thank you.
Thank you.
Can I get H?
Can I get a
Hawaii
follow-up question, Chair?
Oh,
Rep. Shimizu, and then Rep. Cochran.
Director Johnson. Yes. Your last statement that there were instances where a person was released on compassionate release and they didn't do what they were supposed to. I heard from an earlier testimony today from the Office of Public Defender that if the person is released and they don't follow what is required, that they would be recommitted. So isn't that a safeguard and addresses what you're stating?
It is, but if the Department of Public Safety doesn't have the capacity to take care of them, then they'll apply for compassionate release again. And in order to get the care they need, they would probably be released again into the community. So what happens then? They still don't care, they still don't follow the terms and conditions of parole. I'm not saying everybody that gets out on compassionate release does that, but we have had instances with that, and they were not terminally ill. They did have issues, serious health issues. So I'm not trying to paint every offender with a broad brush. I'm just saying that the DCR believes those two category offenders should not be considered. That's all. The legislature can pass whatever legislation you deem fit. We will follow the law. I want to make that clear.
So you think that those exceptional cases of that didn't work out outweighs all of the positive that can benefit the people that really need it?
No, I'm just saying you should consider that. That's all.
Yep. Okay. Cochran,
For
final question?
HPA. So I heard concerns about on the victims aspect, right? And that there's no notification and all that. I understand this does have you folks hold an administrative hearing. Is this public? Does this where the victims are notified that such, a hearing is occurring?
So there is a 48-hour notice. It's an abbreviated notice. They normally get 60 days for our minimum hearings in regular cases. But because of the expedited nature of these proceedings, we send out a 48-hour notice.
And this is to victims and prosecutor attorney's offices and anyone who's involved with this particular case.
That's correct.
Indictment, whatever conviction. So they are notified. I mean, because I heard people saying there isn't.
They are notified.
Okay. And is this a public type hearing?
It is not.
Okay, closed sort of court sort of thing. Okay, and also this, Ms. Brady mentioned there's very few that would maybe fall into this category of compassionate release. Do you have like a number?
Sure.
At this time?
So let me provide that now. So in the last 3 years, there were 13 compassionate release applications that made its way from DCR to HPA. All 13 were granted compassionate release. All 13 in the last 3 years. 8 of these inmates were released, 4 were granted release but are pending getting out the door for lack of placement, proper care, and so forth. 1 inmate had passed away after being granted release while getting that care placement in the community secured. Let me also say that this notion about people being medically released or on compassionate release not having the capability to do further harm to either victims and or the general community needs to consider we have a case who's a paraplegic, bedridden, out on the west side, is now facing 4 new felony charges. A friend of his had brought him a firearm and he decided to shoot up his mother's garage where he was living because he had a argument with his mother. We have other cases that have posed problems to our community and to our parole officers. They're basically saying, my life is over, I'm gonna do what I wanna do, I'm gonna smoke, I'm gonna drink, and I'm gonna take care of myself and not worry about you. And that's a problem. So when you talk about having to manage them in the community, they are still getting back into their addiction and criminal activity. The problem with revoking these individuals is exactly what Director Johnson brought up. If this bill passes the way it is, then we as the board will need to consider their medical and or mental health condition and or incapacitation in relation to the nature of the violations and where that proper care could be provided. So you're talking about a very complex issue that will require a lot of thinking about.
Sure, just one follow-up, please, real quick. And
Okay.
so I heard testimony about, I think, public defender and others said the HB had some really helpful verbiage in there. Are you familiar and would you be amenable to that? Would it make it a lot more palatable if those types of amendments were inserted into this particular bill?
I would really have to go back and review that
Okay,
version.
all right, that's fine. And then I'm sorry, the gentleman here that was in and came out, LAP, I think was his organization that helps with, no, but sir, I was gonna ask you, the ones that you said medical release, they're pending. You have a bunch that are pending because there's nowhere for them to go.
Right,
But perhaps have you reached out to an entity like his that can help, you know,
It
have a
depends on what
transitional-
the needs of the inmate is, yeah.
Sorry, yeah.
Yeah, if they need extensive medical care and in a facility or like a care home, then Matt's place may not be appropriate.
Okay, okay. Well, thank you for your time.
Okay,
Thank
you're
you
welcome.
for your explanation.
Thank you, Rep.
Chair.
Cochran. Any other questions? If not,
Chair.
thank you.
Thank you, Chair.
Thank you very much to all the testifiers on this measure. I appreciate you taking your time to come in and testify on this. We're gonna move on to the next measure. Okay, next measure, Senate Bill 2575, Senate Draft 2 relating to firearms. This measure establishes mandatory minimum terms of imprisonment for certain Class A felonies involving firearms. Changes from a Class B felony to a Class A felony. The penalty for owning, possessing, or controlling any firearm or ammunition while being prosecuted for or having been convicted of committing a felony, a crime of violence, criminal offense related to firearms, or an illegal sale or distribution of any drug. Changes from a misdemeanor to a Class A felony, the penalty for ownership, possession, control, or transfer of ownership of any firearms or ammunition by a person who a court order has restrained from contacting, threatening, or physically abusing any person. Also changes from a misdemeanor to a Class A felony, the penalty for carrying a firearm while under the influence of a controlled substance. And finally establishes unlawful possession of methamphetamine while carrying a firearm as a Class A felony. First up, we have the Office of the Public Defender.
Good afternoon. The Office of the Public Defender respectfully has submitted opposition to this measure. And before I start my testimony, we want to first acknowledge that the committee is going to understandably hear a lot of support for this measure. And I want to frame the degree of our opposition. We absolutely understand the reaction and the response to want to address the tragedy that occurred and the namesake of this bill. And we believe that perhaps there are measures that need to be taken to address some of the concerns. Where our opposition lies is respectfully within the four corners of this measure, and that those are some of the things that I'd like to highlight right now. First and foremost, I just want to put into context what a Class A felony is. A Class A felony is reserved for the most egregious offenses in our legal system, our criminal legal system. And what we are talking about here is not the acts that are sometimes associated with firearms. We are talking about basically possession or control, and in some cases, the use of them. But really what this measure is doing is seeking to enhance penalties for having a firearm. A Class A felony under our current structure is reserved for murder, manslaughter, attempted murder, continuous sexual assault of a minor, sexual assault in the first degree, robbery in the first degree, with a weapon, to name a few. So I just want to highlight for this committee. Also, the language in this measure that says no possibility of parole. A Class A felony under our current sentencing structure requires an open 20-year term of incarceration. What this measure would do would make that open nature of any prison term irrelevant, as somebody would have to serve all 20 years. It takes away any discretion from the paroling authority to decide whether that person has been reasonably and meaningfully rehabilitated. And so that is our opposition as well. And I know I'm coming up in my time, but I just wanted to highlight for everyone's benefit the current sentencing options that we already have in our existing system. Right now, there are mandatory minimum sentences if you are sentenced with the use of a firearm, and that is highlighted in our testimony and found in Hawaii Revised Statute 706-660.1. You already have measures in place to deal with the severity of possessions of guns for those who should not lawfully have them. We also have extended terms of imprisonment, which can extend Class A felonies or our existing opening terms to double. So a 10-year term can be extended to a 20 in certain circumstances, but that gives the courts the discretion to examine and look at the offender and all of the circumstances surrounding it. I'd also just like to highlight that the court can impose consecutive sentencing if there's multiple charges. So there are a lot of existing options. What we want to do is just make sure that everyone is aware of that, and that we note that our opposition, again, is not to the crime that was committed here. We understand that, and that individual has been charged with the most serious offense in our penal code, which is murder in the first degree, which carries life without the possibility of parole, and appropriately so. Our opposition is just to this language of possession of guns and all of these enhancements that this measure is seeking to create. I'll be available for questions. Thank you for the opportunity to testify.
Thank you very much. Next, the Department of Law Enforcement.
Good afternoon. I'm Jared Ridula. I'm the Deputy Director for Law Enforcement. Our department is in support of this measure. One of the most important functions of the criminal law is to deter criminal activity. Keeping that in mind, when a person is a convicted felon or when they're restricted by a restraining order and they decide to get involved with guns, that is a huge calculus. So significant that it should carry with it the most significant of consequences. Last October, in addition to that, I received a call no police chief wants to hear, that one of my officers had been shot during a drug raid by a person who was already a prohibited person, not supposed to have guns, and got involved with drugs. For the safety of our community and to deter future criminal activity like this, it should have significant criminal consequences. Thank you for the opportunity to testify.
Next, Chief Vanek.
Hello, Chair, Vice Chair, Council Member, Committee members. I'm Chief Vanek, Interim Chief Vanek of the Honolulu Police Department. Thank you for the opportunity to provide testimony. We're going to stand on the testimony that we submitted, but I just want to point out, like the Department of Law Enforcement, and I'm sure you're going to hear the other chiefs also talk about it. Anytime individuals are out there and there's a combination of firearms and drugs, which our officers routinely come into contact with, that's a dangerous combination. Not only is that a danger for our officers, that's a danger for our public. So what this bill does is that really helps to keep not only the public safe, but our officers safe. So that's why we're supporting this bill. So I strongly urge you to support this bill as well. Thank you, and I'm here for questions if you have any.
Thank you very much for being here, Chief Vanek. Next, Chief Mahuna.
Good afternoon, Chair Tarnas, Vice Chair Poipoi, and distinguished members of the committee. My name is Reed Mahuna. I have the honor of serving as the Chief of Police of the Hawaii Police Department. I'm here to speak in strong support of Senate Bill 2575 SD2, also known as the Officer Suzanne O. Crime Bill. I did intend to appear via Zoom and I have submitted written testimony, but out of respect for Officer O and for all those who have been lost to gun violence, I felt it was important to come here in person and share a story that I have not spoken about publicly before. On the night of July 18th, 2018, I was a lieutenant working in Puna. I wasn't assigned to the district at the time. I was there on a special detail helping oversee the response to the ongoing lava flow. It was late, about 9:30 at night, and I was at the Pahoa station when I heard a call come over the radio. At first, it was just fragments, a report of shots fired, confusion, raised voices. The call wasn't clear, and I was far from the scene. But I got in my car and I started driving as fast as I could. As the radio continued, I heard something that has stayed with me to this day. The tone of an officer's voice. There was desperation in it. He was asking where the medic was. He was asking for help. I remember taking the radio and telling him to put the officer in the car and start driving. And I remember hearing his answer that he couldn't do it. At some point, I noticed a sharp pain in my leg, and for a moment I was confused, and then I realized it was because I was pressing so hard on the gas pedal. I was trying to get there just a little bit faster. I remember seeing the ambulance racing toward the scene faster than I have ever seen an ambulance drive. Lights and siren cutting through what would end up being a horrible night. When I arrived, the scene was not yet safe. The suspect was not in custody. There was still that uncertainty, that danger that every officer understands but can never fully describe. Then I saw Officer Bronson Kaliloa lying on the roadway, medics working on him, doing everything they could. At that moment, my first thought was, oh my God, his kids, his wife. I could see his injuries and I knew they were catastrophic. Bronson was a hero to the very end. He fought for his life, he fought for his wife, he fought for his children, and he fought for this community. But in the end, he did not make it. That night changed me forever. I am not the same person I was before July 18th, 2018. I have not spoken about this publicly until now, in part because there are many people who were closer to Bronson than I was. His family, his closest fellow officers, and I've always felt that their pain was far greater than mine. But the truth is, we all carry the loss. Some of us in big visible ways, and some of us in quiet ways that never leave us. When I think about Officer Suzanne Oh, I think about Bronson, I think about their families. I think about how many times in Hawaii and across the country, someone who should have never had a gun in the first place ends up with one, and someone doesn't go home. This bill would not have saved Officer Kaliloa, and it may not have even saved Officer Oh. No single law can promise that. But Senate Bill 2575 targets some of the most dangerous situations we see. People who are already prohibited from having firearms, people who ignore court orders, people who mix guns with serious drugs, and people who choose to carry firearms while under the influence. It says that when you are in one of these high-risk categories and you still choose to arm yourself, there will be serious and certain consequences. I am convinced that this bill will save lives. Not every life, not every tragedy, but some. And those lives will be saved in the honor of Officer Suzanne Oh, in honor of Officer Bronson Kaliloa, and in honor of every person in Hawaii who has been taken by gun violence at the hands of someone who should have never had a gun. So today, I ask that we move forward a bill that is as strong as we can make it. Let us stand together in law enforcement, in the legislature, and in our communities and fight for a safer Hawaii. Mahalo for this opportunity to testify, and I will be happy to answer any questions. Thank you.
Thank you, Chief Mahuna. Chief Pelletier?
Aloha, Chair, Vice Chair, members of the committee. Mahalo for the opportunity to testify in strong support of SB 2575. Today, we are not just discussing a bill, we are honoring a life. Officer Suzanne Oh served her community with courage, integrity, and an unwavering commitment to protect others. She put on a uniform, knowing the risks, and she paid the ultimate price. The bill ensures that her sacrifice and the sacrifice of all others are never met with anything less than the full weight of accountability. SB 2575 establishes a clear, firm consequence, a mandatory 20-year sentence for those who are already prohibited. Remember this, they were already convicted. A judge already had them in front. They already went through a system, and then they chose, knowing full well that they shouldn't pick up a gun, or they're under the influence of a controlled substance, or they're served with a protective order. These are people that should not have firearms. This bill is not about punishment alone. It is about deterrence, justice, and a reaffirmation of our collective values. Prohibited persons with firearms are not just attacking individuals. They are attacking the rule of law, the public safety, and the very fabric of our communities. This bill is supported by all 4 county agencies, by DLE, by SHOPO. I do not know of a time, ever, me personally, that you have had that amount of unified support in front of you, asking, begging, pleading for something to make our community safer. While no law can erase the loss of Suzanne, we have a responsibility to act, to send a clear message that firearm-related criminal violence, again, firearm-related criminal violence will be met with decisive consequences. Our officers stand on the front lines every day in Hawaii, often facing unpredictable, dangerous situations. They do so to ensure that our families are safe, our neighborhoods are secure, and that our very way of life is preserved. She deserves to know that their state stands behind them. This bill will make Hawaii safer, and I respectfully urge this committee to support the measure. God bless you. Mahalo.
Thanks, Chief Pelletier. We have a number of other testifiers from the police department, but out of respect, I'd like to ask Officer O's brother to come up and testify. Shen?
Good afternoon, Chair, Vice Chair, members of the committee. Aloha and talofa. My name is Shen O. I am the brother of Officer Suzanne O for MPD. Today I stand before you guys to witness, but not just the brother, but the brother whose life was forever changed by the loss of my sister, Officer Suzanne O. I strongly support this Senate Bill 2575. The night we lost her, our world stopped. Not just mine, I'm pretty sure every single community. There is no way that I can fully describe the emptiness left behind that someone so full of life is taken in an instant. Birthdays, holidays, simple phone calls, and all that feel different now. There's no permanent silence. Her voice used to be. But Suzanne's story cannot end with tragedy. This bill, in her honor, is about more than a policy, just like Chief Pelletier was saying. It's about accountability, protection, and preventing other families from experiencing this kind of loss. It's about standing up for the men and women who put their lives on the line every single day and ensuring that their sacrifices are not met with preventable harm or injustice. This bill can save one life, can protect even one officer. If it can give one family more time with their loved one, then Suzanne's legacy continues in a powerful way. She believed in what she was doing, she was right, even when it was hard. And today, I ask that we do the same. Not just for Suzanne, but for every Ohana and every life that depends on these choices we made in this room. Thank you. Mahalo. Fatai love for your time.
Thank you, Mr. Rowe. Appreciate you being here. Rudy Tai, Kauai Police Department on Zoom. Please proceed.
Hello, Honorable Chair Tarnas, Vice Chair Poi Poi, and members of the committee. My name is Rudy Tai. I'm the Police Chief of Kauai. On behalf of the Kauai Police Department, we strongly support SB 2575. The intent of this bill imposes stricter penalties on individuals who unlawfully possess or use firearms, particularly those already prohibited due to criminal activity or court orders. By prioritizing community safety and accountability, this measure makes clear that individuals who are already engaged in unlawful conduct or subject to court-ordered restrictions must not be permitted to possess or carry firearms in the state of Hawaii. And it reinforces penalties for serious firearms offenses. SB 2575 also reflects our collective responsibility to support those who we serve and protect our communities daily while honoring Maui Police Department's fallen officer O. It stands as a reminder of the sacrifices made by law enforcement officers across Hawaii and acknowledges the lasting impact on the families they leave behind. While no measure can change past outcomes, we can and should act to reduce the likely future of loss. Thank you for the opportunity to testify.
Thank you, Chief Tai. Next, Arnold Sagusio, Honolulu Police Department.
Good afternoon, Chair Tarnas and Vice Chair Poipoy and the committee members. We're the Arnold Sagusio, the Acting Major of the Records and Identification Division of the Honolulu Police Department. We're in strong support of the bill and we rest on our testimony that we provided. Thank you for any questions.
Thank you very much. Austin Martin on Zoom, not present. Melissa Pavlicek.
Good afternoon, Chair Tarnas, Vice Chair Poipoy, and members of the committee. My name is Don Famuina, and I'm the president of the State of Hawaii Organization of Police Officers, better known as SHOPO. I'm in strong support of this current bill. I had this whole presentation to share with you, but I think my colleagues, the chiefs from all the 4 counties, as well as Suzanne's brother, pretty much said everything. And I'll be very honest with you, I don't know Suzanne, but let me tell you what I do know. We share a lot of similarities. Suzanne and I come from the same hometown, right in Kalihi. We graduated from the best high school in Hawaii, Farrington, go Govs, along with Captain Sagusio behind me. We're both immigrants from Samoa, and our sole purpose is just to make our people proud and serve the community that we love. But more importantly, the one thing that Suzanne and I share is that the love we have for law enforcement and the communities that we share. I just want to say in closing that Officer Suzanne Wu made the ultimate sacrifice in the protection of others, and her loss is a solemn reminder of the risk our officers face every day. Naming this measure in her memory reflects the legislature's commitment to officer safety. Mahalo.
Thank you very much. Next, Michael Rice on Zoom, not present. Next, Dennis Dunn on Zoom, not present. Next, Stacy Moniz on Zoom, not present. Anyone else wishing to testify on Senate Bill 2575? Come on up, introduce yourself.
Good afternoon, Chair, members of the committee. My name is Cameron Hurt, and I'm here testifying on this bill as an individual. I feel like we've heard a lot of great testimony from the police force, but I give one from the citizenry. I had a sister who was stabbed 25 times in her bathroom while her daughter hid under the bed, who was 4 at the time. My sister passed. I'll never forget the first hearing that we had for her case, where they said that there was a potential that her killer could get 13 years. This was not in this state. Her killer could get 13 years. So to be prepared for that is the worst case scenario. I'm a man of God, I'm a man of love, and I have a lot of compassion and grace to give. But to ask me to have to deal with a killer of my sister 13 years after her horrific murder, when her daughter wouldn't even be 18, did not seem fair. Luckily, we ended up getting 27 years. If you ask me, that's never gonna be enough, because I'm never gonna get my sister back. My niece is never gonna get her mom back. Protect officers, yes, a deterrent, but protect the families. When people are able to be released, it's not that people don't wanna see them do well if they can be rehabilitated. But it's a thing of, it's a certain type of trauma when victims' families have to know that their murderers of their family members are in the general public. And it really asks yourself, and it begs the question, can you exist in a city, in a state, in a community where they are and you feel safe? So I just wanted to add that and say I strongly support the bill as an individual. Thank you.
Thank you, Mr. Hurt. Anyone else wishing to testify on this measure? If not, questions, members? Rep. Cochran?
Thank you, Chief Pelletier from Maui. Aloha, Chief.
Aloha.
Thanks for coming all this way from Maui to Hawaii, and appreciate your time and putting this together on behalf of, yeah. So I guess my biggest question is, will this make a difference?
Mahalo, Representative Cochran. In my heart, I really do believe it. And I would just like to say, when we put this together, we took what happened to Suzanne, and we looked at that case without getting into all the specifics, because there's a trial and I am the head of the agency. We took that and we said, what did this individual do, and how can we prevent this from happening to anyone? And again, you want a deterrence for accountability. And the individuals that we're talking about, they're already convicted ex-felons. They already had their day in court. They already did. And they already know they can't have a gun. But they ignore it because it's too lenient. They don't care. They don't listen. So we wanted to create something that says that's not okay here. And you know, and this is why I think it works too. There's testimony earlier about we don't want the federal government to come in. We don't want HSI. We don't want the FBI. 15 years if it's a federal case. So if there's an ex-felon with a gun, we as law enforcement, we go to the feds and we say, hey, I'm only gonna get a couple years here in the state with this charge. But you can get me 15 years, can you adopt it and go federally? So you force us to go federally. Why not make it where every single ex-felon in the other 49 states do not want to come here, because if they do and they commit a crime with a gun, they're gonna go to prison for 20 years. You know, I appreciate Mr. Hurt's testimony. I thought that was extremely compassionate because he talked about his family. I didn't know he was gonna say that. But he was real and he was wrong. You talk about Shen. So I do think it'll make a difference, because I believe it'll cause people to second guess whether they pick up that gun. If they know that there's a gun in that situation, they get out of that situation. If you're served with the TRO, and I will share this, where that murder of our officer took place is a short distance from the shelter that the family was hiding that just served that individual a couple days prior. My personal opinion only is I believe he was going to hunt to kill them. But if you have a charge now that all of a sudden makes this a lot more serious, are you gonna pick up the gun? And so you think about this, it's only affecting people that already shouldn't have guns.
Thank you.
Yes.
Thank you,
Any
and
other
Chief, thank you. Yeah, and just one follow-up, Chief, thank you again for that explanation. I mean, I know there's never a perfect bill,
Okay.
but if there was something you wanted to add to make it towards maybe a perfect bill, is there something you did here?
It's a very fair question. I would say this, if we're gonna sit here and have an honest debate of what amendment or what would I do to make it where it is the fairest bill, right, maybe compassionate, I would add in the narcotics part or the controlled substance part, I would put unless prescribed. Like, and I'll just use, like, maybe there's an adult with ADHD, maybe they're on Adderall, okay, maybe it shouldn't be. So if there is a lawful prescription, I have no problem us having the ability to consider that, and then this not applying it in that sense, because we all know you're not gonna get a prescription for methamphetamine, you're not gonna get a prescription for cocaine. But there are other things that maybe you do have a medical need for, and I can understand that. I wouldn't come off, the federal system is 15. The judge already got a bite at the apple and it didn't work. And so that's why I would say I would really encourage us to keep that or be reasonable with the length on that. But I wouldn't be opposed if you made with a prescription.
Okay, and just a clarification on that comment, Chief. So you're saying something like unless prescribed a controlled substance or
So
a
like
schedule?
because it's schedules 1 through 3, right? So certain threes, people in this room might be under certain threes, right, even now. But if you have a prescription, then you have a legal reason to have that. I don't think that should preclude you or cause the Suzanne O law to then kick in. I think that there should be a reasonable accommodation because you have a prescription.
Okay, well, thank you again, and thank you for your time and coming here.
Thank you very much.
Other questions? If not, I wanna say thank you to all the testifiers. This was a very difficult tragedy that motivated the Maui Police Department and legislators to propose this measure. And I wanna acknowledge that. It was a severe tragedy. And I appreciate you, sir, the brother of the fallen officer, to be here today. That's very difficult.
Sure.
So I appreciate you being here, and thank you to all the other testifiers as well. So I'd like to move on to the next measure. You asked your
Sorry.
questions. Did you have another question?
I had a clarifying question, I think to address public defender's office.
Did you have a question
And it
for the
was, yes,
Public
I do.
Defender's Office?
No, it's actually a question maybe for the authors, or maybe,
This-
I don't know,
there-
Chief Pelletier or,
The author is a
not the author, but I
legislator.
mean the people who worked on this,
Choose
such
your-
as
Choose the person you wanna ask the question of.
Chief Pelletier, I suppose, since I'm more familiar with yourself being from Maui and all. There was a point made that possession, the word possession is not defined. So because it was said that constructive possession, meaning not an actual possession, can be is in this.
So the beauty of that is that's where the court comes in, and the prosecution would then argue what the constructive possession is. The defense would then argue that they weren't in possession. And so the beauty of it is that's open to interpretation for the court, and it would be decided there. We all know what possession means, and the other side's gonna say, these aren't my pants. But you're wearing the pants. And so the beauty of that, and I'm being honest, because we've all had bad guys and we've said, you know, the cocaine's in your pants. These aren't my pants. I'm not making that up. And so that therein lies part of it, is let's allow the court system to then let that play out.
Okay, all right, well, thank you.
Thank you.
Thanks for that explanation. That's it, thank you. Sorry,
Okay.
Chair.
And I just wanna say again, as we wrap up testimony on this measure, thank you to all the testifiers. I know you've got very strong feelings about this, and I appreciate you taking the time to come in here, answer questions, provide your testimony, so I appreciate it, okay? We're now gonna move on to bills that are on voter registration and procurement and insurance. So there's a lot of other things we'll do. We'll make decisions at the end of the hearing. So if you need to leave, please do. If you wanna stay, you're welcome to stay. Okay, thank you. We'll move on to the next measure. Senate Bill 2239, Senate Draft 1, relating to voter registration. This measure requires a person who applies for an identification card or driver's license to be automatically registered to vote unless the person affirmatively declines. The measure requires the name and address of a person who applies for an identification card or driver's license and is registered to vote to be automatically updated on the person's voter registration record unless the person affirmatively declines. In this measure, first up, we have the State of Hawaii Office of Elections, our Director, Scott Nago.
Good afternoon. Thank you for the opportunity to provide testimony on this measure. We support the intent of this bill, and we appreciate the committee's efforts to expand access to voting and strengthen civic engagement. However, we would like to note that the Federal National Voter Registration Act requires that an applicant attest to the following statements: they're a citizen, they are 18 years of age, and they're a resident of the state of Hawaii. So we would just like to note that it's not included in this bill, but we believe the National Voter Registration Act required.
Understood. Thank
Yeah,
you.
thank you.
Thank you very much. Attorney General?
Good afternoon, Chair, Vice Chair, members of the committee. Charles Lee, Deputy Attorney General. Kind of mirroring what was just said, we just want to note that the state and federal law require specific attestation. And so if the committee could consider adding that in, help make the implementation better. Thank you.
Thank you for your testimony. Next, Sandy Hardrow Livingston on Zoom, not present. Next, Jamie Detweiler on Zoom. Please proceed, Ms. Detweiler.
Thank you. Aloha Chair Tarnas, Vice Chair Poi Poi, and members of the committee. Jamie Detweiler, Hawaiian Islands Republican Women. Thank you for this opportunity to testify in opposition to SB 2239 SD1. Automatic voter registration lacks a paper trail. Therefore, it raises concerns regarding the auditability of this database, right? And currently, individuals have to opt in. What this measure is saying is that it's reinforcing automatic opt-in. So it's changing the current practice, stipulating that applicants shall be registered to vote by default unless they explicitly choose to opt out. There are other issues of concern, including addresses. So you may have an individual that comes in for services to any of our state agencies, whether it's motor vehicle registration or DLIR for, employment benefits. Where are we tracking any possibilities of duplication of applications? Sometimes people move. Are we keeping these individuals on the voter rolls? Sometimes they leave out a middle name or add in a middle name. Is the system going to be set up to identify the duplicity in this database? Also, some of the concerns include a strain on resources and administrative capabilities on state agencies, county clerks, and the Office of Elections. There's also the element of startup costs, which I don't believe this measure addresses any startup costs to develop this database. And the issue of privacy and security, we're transmitting sensitive information across agencies. How is this going to be protected? And one of the greatest concerns for us is that we should be cleaning the voter rolls before we start adding any new voters to the voter roll. We also have concerns about the self-attestation. So we have a solution for all of this. The solution is, I know at the federal level, it's currently a very hot topic. It's the Save America Act. But should that be implemented, that would address many of the concerns that I've stated here today. It will simplify the matter. It will make sure that we have people who are eligible to vote registering to vote. So, I don't know how the state agencies are going to add this to the work that our frontline workers, such as, SNAP, Medicaid, DLIR, DMV, they're already taxed with their primary duties. So there are many concerns, but we have that solution. And hopefully it gets resolved at the national level to implement the Save America Act. So please vote no on SB 2239. Thank you for this opportunity to testify.
Thank you, Ms. Detweiler. Next, Cameron Hurt, Common Cause.
Thank you, Chair Tarnas, members of the committee. My name is Cameron Hurt, Common Cause Hawaii. So we're standing in strong support of this bill. You guys have heard me talk about the cost benefits before, how this is actually a net save for us. What I do want to address though today, speaking about this, or more so the misconceptions. As I understand it, this bill and its new draft and its newest version would only include the DMV. If it's only including the DMV, then we're talking about the agency that goes through issuing out real IDs. So we know that in order to get a real ID, you must present proof of citizenship. We know that if you cannot, you get in our state what's called a conditional ID, which would show that for some reason you could not get a real ID. So to this notion that somehow we're going to get so many people who can just register unabashedly, it's not backed up in fact. And then when we talk about voter fraud in general when it comes to this bill, which has nothing really to do with voter fraud, but if we want to talk about voter fraud, which is fine, then we must address the fact that it is a 0.003% problem across administrations, across parties. That's agreed upon. Now, no, it's not going to be perfect. Nothing is perfect, but Jesus Christ, my grandmother used to tell me. In that case, then, a 0.003% average is dang good, especially in government. So there is nothing that we're not doing already. The issues around this bill really have to do with federal statutes more than what we can do here in a state. This is already happening in 7 states, mind you. And we're not talking about the most liberal states in our union. We're not talking about California and New York. We're talking about our Alaskas. We're talking about our Nevadas. We are talking about our Colorados. Those are the people who are enacting this. We're talking about DC. We are also talking about a bill, a practice that has withstood 2 Trump administrations with no court challenges, mind you. So I am here for safe and secure elections. Tell me where to show up and I'll fight with you for it. But when it comes to this bill, you're literally going to the people who give you the real ID. So I just wanted to address those concerns primarily. Thank you, guys.
Thank you, Mr. Hurt. Next, Michael Galoyu.
Good afternoon, Michael Galoyu Jr., he, him pronouns, president of Pride at Work Hawaii. Pride at Work Hawaii stands in strong support of this legislation. AVR works, automatic voter registration works. I do want to correct the previous speaker. We actually have it in 10 states now. And there is, as he stated in his testimony, there is not voter fraud. Voter fraud is a red herring brought to you by those that do not like the name that they are. So I will not say that out of respect for you, Chair.
Thank you.
You're very welcome, Chair. AVR works. AVR is, we represent unions. We represent the working class. We have here in Hawaii, we need to lower the barriers because voting is a right. And the more barriers that people want to put in place of people those that are eligible to be able to vote is un-American. It's disrespectful to who we are as a people. And so we encourage you to pass this bill. The amendments are there that who are we going to trust? The people that give you the real IDs, or are we going to trust people that read something on Google? They Google something, and so they then think, oh, I now know everything about voter registration. If 10 other states can do it, we certainly can. Oh, and the District of Columbia, sorry. And so we have our working families that are working 2-3 jobs. And so when they go into the DMV to go in and get their driver's licenses, automatically registering to vote, they will be able to check those things if they are citizens and if they're eligible at that location at that time. And so it just makes sense. We encourage you to pass this, lower the barriers. I believe everybody that has the right to vote should be able to vote, and we need to make it easier. And the audacity that we should be stripping people off the voter rolls is un-American as well. And I just don't understand how anybody could support that as well.
Thank you.
So again, pass this bill, please. I thank you for your time, and I'm available for questions.
Thank you. Next, Hoku Pak on Zoom. Not present. Anyone else wishing to testify in this measure? If not, questions, members?
Mr. Chair.
Rep. Garcia?
Thank you, Chair. For the AG, please. So my understanding from the testimony, the bill as written would be in violation of federal law?
Potentially, without the attestation.
Without having attestation would violate which federal act or federal law?
It would be 52 USC section 20504 C2C.
Okay, thank you very much. And one follow-up question here for Mr. Nago. Thank you for being here. I just want to say and clarify, yes, Hawaii already has automatic voter registration. But it is an opt-in process. This would make it an automatically occurrence unless you choose to opt out. Question, since Hawaii passed the Automatic Voter Registration Act some years back, how many names were added to the voter rolls from that passage of that act?
Like I said the last time, I don't really have that number, but we're not really, it doesn't benefit the new registrants more so as people who moved. We have a transit state. You need to keep your registration updated. So and you also need to keep your driver's license updated. So when you go in to get your new driver's license with your new address, you'll be able to register at the same time instead of having to go to 2 spots. And that's the benefit we see in this.
And what process does your office use to check if somebody, say, signs up for a driver's license here and they're going through the process of automatically registering, that they're not registered in another state? How do you check on that?
So there is not a process to check on registration in other states unless that person says that they're registered in another state. Then
okay.
When they do that, we will send the notification to the other state that this person has registered in Hawaii. You may want to do follow-up to remove them from.
So they have to tell you that
They have to
themselves.
tell us that.
Otherwise, they could be registered in 3 states and they would automatically be registered here in Hawaii. Potentially.
Yes, potentially, but we have something coming online, which is the Electronic Registration Information Center, or ERIC, which would potentially eliminate that with ERIC states.
Got it. Thank you.
Other questions, members? If not, Rep. Shimizu?
Thank you, Chair. Mr. Nago, there was a statement by testifier about cleaning up the voter rolls. So with this automatic registration and possibly a lot of new voters coming on, would that be a problem with you, cleaning up the voter rolls?
I don't understand which. So the way the
Maybe
voter.
you could explain
how
how
the
you
voter
maintain the
okay.
rolls.
So the way the voter rolls are maintained is pursuant to the National Voter Registration Act, which voters, the only way a voter can be removed is if a mailing comes back, an election mailing comes back, such as your ballot or your yellow card, your voter notification card. Even when that comes back, we still have to follow up with a affordable card. And then once we do that, the voter gets is inactive for 2 general elections before they can finally be removed. So that's the only, we cannot remove somebody for not voting. The federal law specifically says how you can remove it.
So your voter maintenance process is really dictated by federal law.
Yeah, and you need to have 2 election cycles, 2 general elections go by before you finally definitively get removed.
And how often do you mail out those yellow cards you're talking about?
Every election. So it should be coming soon for this election.
Just every 2 years?
Yes. All voters get a yellow card prior to each election.
Coming soon
Prior
to a
to the
mailbox
elections.
near you.
So if you do receive one that's for a voter that's no longer there, don't throw it away. You should put not at this address and return it so that we can start the process.
Thank you, Chair.
Sure. Any other questions? If
Sure.
not, yes.
Sorry, real quick,
Rep. Cochran?
so, Mr. Nago, thank you for being here. What about people who pass away?
That we get if you pass away in the state of Hawaii, we get a death list from the Department of Health.
Alright, thanks, thank you, Chair.
Okay, thank you. Thank you very much to all the testifiers. Let's move on to the next measure. Senate Bill 2601, Senate Draft 2, related to procurement. This measure ensures that awarded contracts are supported by sufficient appropriations by requiring the contract amount does not exceed 10% of the amount of the appropriation or balance of an appropriation that is available to cover the cost of the contract. It requires a contract that exceeds the 10% threshold to be approved by the Chief Procurement Officer, amends the criminal penalties under the Hawaii Public Procurement Code by providing that a person who intentionally violates the code is guilty of a petty misdemeanor for the first offense and a misdemeanor for any subsequent offense. It also establishes positions within the State Procurement Office and appropriates funds. First up, we have the State Procurement Office.
Chair, Vice Chair, members of the committee, my name is Dana Omiya, Assistant Administrator with the State Procurement Office. We stand on our written testimony providing comments.
Do you want to highlight your, if nothing else, your amendments?
Oh yeah, our recommendations
Yes.
to this bill. Yes. So the first one is the Senate Draft 2 includes the language that stipulates that any intentional violation of the Hawaii Procurement Code is subject to a petty misdemeanor for the first offense and a misdemeanor for second and any offenses after that. So what we initially proposed in our language was, our recommended language was to include the misdemeanors for any egregious violation of the procurement code, not just any violation of the procurement code. Secondly, we also included a 15% threshold versus the 10 because it's just it would be an administrative burden to each jurisdiction. So there's 22 jurisdictions, each with their own CPO, and so you also
Chief Procurement Officer.
Chief Procurement Officer.
People
Sorry.
don't use acronyms in this committee because no one remembers them all. So if you could just tell us what it means instead of using an acronym, it would help everybody,
Okay.
including the public who's watching you.
Chief Procurement Officers, CPO. And so this bill also includes an FTE position within the State Procurement Office to address those administrative burdens, but there's 21 other jurisdictions besides Hubani Kahukui is the administrator. She's the CPO for the executive branch. So there's 21 other jurisdictions, each with their own CPO. So those are just highlighting what we
I appreciate you
submitted.
providing that highlighting of your amendments so that the public knows and others know what you're suggesting.
Thank you.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members?
Question.
Yep, Rep. Shimizu?
Thank you. Do we have an existing problem and that's the reason we have this bill?
An existing problem?
Yeah, that this bill is trying to address? I guess the way that I understand your testimony, you state referencing HRS section 103D to 309 and also HAR section 3-122-82. They're already what this bill is, to me, the way that I understand this bill, what this bill is trying to achieve is already established based on what you referenced, that there is a process that is in place based on your testimony and your references. That the only thing this bill does is maybe adds penalties for not following what you folks already have in process.
Correct.
So that's why I asked the original question, is there a problem with abuse or needing to increase penalties for mismanagement or wrong administrative processes or something?
As far as I'm aware of, the misdemeanor provision is barely ever used, so I'm not sure why this bill is here.
You have to ask the introducer.
Yes, I'm not exactly sure.
This is not an administration bill.
Okay.
Okay?
Alright, thank you.
Thank
Thanks
you.
Thanks for.
Thank you very much. Any other questions? If not, thank you to all the testifiers. Let's move on to the next measure. Senate Bill 1166 relating to insurance. This measure allows the Hawaii Property Insurance Association and private insurers to bring claims against responsible parties for amounts paid by the insurers for losses resulting from climate disasters and extreme weather attributable to climate change. It requires insurance rates established by the Hawaii Property Insurance Association to account for any proceeds from the civil claims against a responsible party. First up, we have Insurance Division.
Aloha Chair, Representative Shimizu, Matt Sujimura on behalf of the Insurance Division. The Insurance Division doesn't have any comments on the substance of the bill, but we do have concerns that the placement of the proposed language in HRS 431, Chapter 13 is an inappropriate place for that language, as HRS 431.13 is more so the Insurance Code's Unfair and Deceptive Trade Practices section, which regulates the practices of insurance licensees. The division would recommend as an alternative to insert this language into Title 36 under HRS, which would be the civil remedies and defenses and special proceedings chapter of the Hawaii Revised Statute, since it is more so it is proposing a new civil remedy and civil procedure to recover. Even though it's by insurers, it's still not necessarily the regulation of insurers. So that's the only amendment and request that the division has, but happy to answer any questions.
Thank you very much. Next, Wayne Tanaka on Zoom. Mr. Tanaka, are you there?
Oh, yeah, sorry, I'm sorry,
Go ahead.
technical. So, good afternoon, Chair, Vice Chairman of the Committee, Wayne Tanaka, Circle of Hawaii. We are in strong support of this measure. We do have a friendly amendment we'd like to highlight regarding the inclusion of the Hawaii Hurricane Fund as a potential claimant for any payouts from climate-related disasters. Otherwise, happy to answer any questions, and thank you so much for your consideration of this measure.
Thank you very much. Next, Kayla Ikonomu.
Aloha Chair, Vice Chair, and members of the committee. Thank you for the opportunity to testify. My name is Kayla Economo, and I am testifying on behalf of the Polluters Pay Hawaii Coalition. Polluters Pay Hawaii stands in strong support of SB 1166 with amendments outlined in our written testimony. Hawaii is currently on the front lines of a climate crisis and an insurance crisis. Both are intertwined and accelerating. The past few weeks have just shown with the Kona low storms, some of the worst flooding that Hawaii has seen in the past 20 years. And then in 2023, we of course had the devastating impacts of the Lahaina fires. These climate-driven disasters are happening more frequently and severely. And in parallel, insurance non-renewals have increased by 216% since 2018, and premiums have gone up by 300% or more in some extreme cases across the state. Hawaii families and residents can't keep absorbing these costs alone. SB 1166 will provide legal tools to help address the economic strain that residents are currently facing with these skyrocketing home insurance rates due to climate change and more extreme weather events occurring. We respectfully urge the committee to pass SB 1166 with amendments. Thank you for the opportunity to testify.
Thank you very much. Hawaiian Council, Madeline McKee.
Aloha Chair Carnes, Vice Chair Poi Poi, members of the committee, Madeline McKeag on behalf of Hawaiian Council, standing on our testimony in strong support. I think we just really wanted to emphasize that we have been directly on the front lines for both the Maui wildfires as well as even in this past week, the storms. And we've seen the devastation firsthand and we've seen the recovery firsthand. And we know that it cannot be just us who is doing this work. I think we feel confident about this bill and then some of the amendments that were put forth, that they can help with the recovery in the long term and that they can bring in the necessary funds that will help with the recovery. We stand in line with the Polluters Pay Coalition potential amendments.
Thank you very much. Next, the Hawaii Insurers Council. Not present. Next, Greenpeace Hawaii, Dave Mullenix. Not present. Next, Gordon Levitt, Center for Climate Integrity.
Chair Tarnas, Vice Chair Poi Poi, and members of the committee, I'm Gordon Levitt on behalf of the Center for Climate Integrity. We stand on our written comments in support, highlighting a few key amendments for the bill. We encourage the committee to provide express statutory authority to the Hawaii Hurricane Relief Fund to bring a civil action for qualifying damages connected to climate disasters. We encourage the committee to amend the definition of qualifying damages to include a broader range of costs and losses that could attach to covered insurance entities under the legislation, and finally to include a robust savings clause that takes into account legal developments in the state since the introduction of the bill last year. With extreme weather disasters becoming more likely and more severe, plus the federal government dismantling its disaster response, Hawaii needs every tool in the toolbox to tackle these problems and lower insurance costs for residents. We urge the committee to pass the bill with the suggested amendments. Thanks for your consideration and the opportunity to testify.
Thank you very much. American Petroleum Institute.
Afternoon, Chair, Vice Chair, members of the committee. Miyamo here on behalf of the American Petroleum Institute, respectfully opposing this measure. Senate Bill 1166 would establish a new liability framework for responsible parties tied to the lawful and heavily regulated petroleum industry. It is the use, sale, and of petroleum-based products. These are the products that the state has permitted, licensed, regulated, and taxed for decades. And what remains essential for emergency services, keeping the lights on, and making sure that we continue to move forward. This bill is being considered when climate-related litigation is already pending here and across the country, including the state of Hawaii, Maui County, and the city and county of Honolulu. Layering a new liability scheme on top of those ongoing litigation raises due process and equal protection concerns and may call into question the validity of active litigation. This uncertainty and open-ended liability exposure could chill future investments and competition in Hawaii's energy system, particularly in a geographically isolated state that already faces some of the highest energy and cost of living burdens. For these reasons, we respectfully request the committee hold this measure. Thank you.
Thank you very much. Next, David Jones on Zoom.
Chair, Vice Chair, my name is Dave Jones. I served as California's Insurance Commissioner from 2011 to 2018. I currently serve as the Director of the Climate Risk Initiative at UC Berkeley School of Law, though I'm testifying today in support of this measure in my individual capacity. Climate change is driving more severe and extreme weather-related events, which are causing insurers to pay out more and more in every state, including Hawaii. Insurers are pushing the cost of climate change onto Hawaiian residents through dramatically increased rates and writing of less insurance. SB 1161 gives insurers and the Hawaii Property Insurance Association the ability to go upstream to the oil and gas industry, whose emissions are one of the major contributors to the climate change that's driving these insurance losses. The Attorney General, the city and the county of city and county in their lawsuits against the oil and gas major do not have the right to recover insurance losses, nor do the insurers, nor does the Hawaii Property Insurance Association, which is why this bill is necessary. I want to address a couple of the comments from the American Petroleum Institute. First, the fact that a product is lawful does not excuse it from having to pay damages for the harms it renders. Second, the API also raises in their letter a concern about the potential double recovery from reinsurers as well as insurers recovering from the oil and gas industry. Reinsurers are very sophisticated. They typically have in their contracts provisions that provide that if the insurer can recover from a third party, much as is contemplated under this bill for losses, that the reinsurer will commensurately recover the portion of reinsurance proceeds it's paid to insurers. So there's no double recovery issue. There's no intrusion on the reinsurance contracts. That's a non-issue. I would urge your support for the bill with the amendments, including the amendment adding the Hawaii Hurricane Relief Fund, which is also greatly exposed to extensive losses associated with climate disasters. It's a critically important stabilization feature in the Hawaii insurance market, but it too should be able to recover for its losses from the oil and gas industry, whose emissions are the major driver of those losses. Happy to take any questions you might have. Thank you.
Thank you very much for your testimony, Mr. Jones. Anyone else wishing to testify on this measure? Mr. Oya?
Good afternoon, Chair, Vice Chair, members of the committee. Evan Oy on behalf of the Hawaii Association for Justice. Apologies if you didn't get our testimony in time. I did just want to stand in opposition to this bill. HHA is very concerned with the current concept and structure of the bill in the sense that it does contradict many of Hawaii's HRS 663, in which a judicial lien process to handle these types of claims, and it contradicts it pretty substantially. And 663 is designed and specifically consumer friendly in the sense that it creates that judicial lien process in which the consumers or the victims in many of these cases are prioritized first, and then the insurance companies have a lien on the judgment that they obtain from the defendant. So in this case, it allows for the money out first to be prioritized towards that victim, and this what operates outside of that, and we are concerned that it creates kind of a almost subrogation of some sort outside of that chapter, and it definitely contradicts what was done in February 25th of last year, in which the court validated Yukimoto, preserving that judicial lien process. So we oppose this bill and are available for any questions. Thank you.
Thank you. And if you would send in your testimony again, I don't see it on our collection.
Apologies for that, Chair. We will get that.
Thank you. Okay, anyone else wishing to testify on this measure? If not, questions, members? If not, yes, Rep. Shimizu?
DCCA. Like we're creating a new reason to create litigation.
Yes, so this would create a new civil remedy that would authorize, sorry, I'm trying to not use the acronym, Hawaii Property Insurance Association, and private insurers to sue fossil fuel companies for insurance-related damages.
So that goes beyond the existing subrogation remedies that are existing in the insurance industry.
Yes, in the sense that subrogation is meant as it is the tool that is used by insurance companies to recover for payouts to insureds or policyholders upon paying out a claim to a policyholder. So say if you lost your home and I the insurance company gave you $1 million, I would then be able to subrogate or go after the party who caused the damage to you on your behalf and recover the money that I gave to you. So this would be sort of a step, I guess, a pivot step in this regard, in the sense that I would pay you your money, and then this bill would allow me as the insurance company to go sue Chevron or a fossil fuel company to recover certain damages that you would have incurred because of that. Or I suppose, from what it sounds like, it's also to account for any rise in premiums due to climate change issues that are sourced from fossil fuel companies.
Okay. Chair, can I ask?
Sure.
Isn't that establishing like a famous precedent that you can create laws to sue people that we get money from?
Well, I think, Representative, to your question, so the Hawaii Attorney General has already filed a suit against fossil fuel companies for climate-related damages. So in the sense that, is this a novel idea? I suppose that's up for interpretation, but since the AG has already initiated a suit, one would deduce that said cause of action already exists in the law. Now, with regards to the authorization of private insurers or the Hawaii Property Insurance Association to sue fossil fuel companies, under the Hawaii revised statutes that have established the Hawaii Property Insurance Association, the Hawaii Property Insurance Association is already authorized to sue and be sued. It's a very broad power. It can be argued that this law would be somewhat duplicative of what the Hawaii Property Insurance Association is already authorized to do. Whether private insurers have the right to sue, I suppose they would have to be able to prove their own damages in order to bring that suit. This would provide a clearer path for them to bring a suit. I do think the question still exists as to, just because you are giving them authorization to do it, will they do it? That's not up to us. So, I think, but to answer your question, does it set a precedent? Yes, in the sense that it would be creating a new civil right of action that is not currently established.
Welcome to the legislature. Great. Thank you, Mr. Sujimura. Any other questions? If not, thank you very much to the testifiers. Let's move on to the next measure. The testifiers for this next measure have been very patient, and I appreciate it. So we're going to move on now to Senate Bill 3247, Senate Draft 1, House Draft 1, relating to Hawaiian affairs. This measure establishes a temporary Royal Mausoleum Working Group within the Department of Land and Natural Resources. It requires the Royal Mausoleum Working Group to submit reports to the legislature and sunsets the working group December 31st, 2027. First up, we have the Attorney General.
Good afternoon, Chair Tarnas, Vice Chair Poipoi, and members of the committee. Deputy Attorney General Alyssa Kao on behalf of the department. The department, first of all, would like to thank the committee, the House Committee on Water and Land, for making many of the suggested amendments that we had suggested in the prior draft. We do have one additional amendment that, however, arose from the committee. So in the in House Draft 1, Section 2 of the bill establishes that the working group would be within DLNR and provides that it shall consist of 7 members. However, there is no process for how these 7 members are going to be selected. And so we would just, our recommendation is just that that the committee clarify that aspect or that process as to how that happens. I'm available if you have any questions. Thank you.
Thank you very much. Department of Land and Natural Resources.
Aloha Chair, Vice Chair, members of the committee, thank you. Appreciate you accepting our late testimony, and I apologize for that. The department is going to stand on their comments, and the comments we have is we would like you to please consider 2 members to the committee, one being DLNR itself and the other being a member of an elite trust. And we notice in the testimony that Kamehameha Schools has put their name forward for consideration, and we would support that. We have been working with the elite trust for the last 14 years on planning and moving forward, where to fix things in the mausoleum grounds. The grounds are DLNR, but the partnership is DLNR and the elite trust for the chapel, and the elite trust take care of the crypts. And so we've been working together on what the needs are, who would pay for it, how would it be paid, who would take the lead on which project. And they meet quarterly until recently when COVID happened, and they've started to regather again. They've been doing it on Teams. So thank you very much for allowing me to present the testimony.
Thank you. Appreciate it. Office of Hawaiian Affairs.
Aloha kākou, lealoha mokuanai on behalf of the Office of Hawaiian Affairs. We support this measure, but I just wanted to highlight that we do have a concern with reducing the size of the working group to just 7 members, especially since this has been basically shifted into a working group that's going to provide a report to the legislature rather than being more of a executive group and commission. So we no longer see the need to reduce it to a size of 7 people and to accurately reflect all of the viewpoints of the Royal Societies, the elite trusts, and some of the other stakeholders relevant lineal descendants, and we think that it's important to expand the group to a number that is appropriate for this working group that includes all of those voices. So that's just our main concern, and we're asking to include those representatives as well as the Association of Hawaiian Civic Clubs, the Office of Hawaiian Affairs as well. I'm available for questions.
Thank you very much. Next, we've got Leimomi Khan.
Aloha mai kākou. Mahalo for allowing us to testify in this bill. So my name is Leimomi Khan. I am the chair of the Ahahipu'u. The Ahahipu'u is comprised of the Royal Order of Kamehameha Chapter 1, the Ahahui Ka'ahumanu, and Hale'ona Ali'i o Hawaii, 3 Royal Benevolent Societies. I am speaking on behalf of the Ahahipu'u, representing these 3 societies. We stand in strong support of this bill with the amendments reflected in our written testimony. And I will just quickly summarize what those amendments were. 1, we addressed the working group composition. We suggested 11 different organizations or people. So by people, I refer to the lineal descendants. And we agreed with the responsibilities that the bill lays out, except that we asked that it be a little bit more specific in terms of saying that our responsibilities would be to review, evaluate, and make recommendations. And then we listed those areas that you had assigned to this working group. The bill is important to us because our mission is to care for and honor our ali'i who rest at Mauna Ala. For generations, our societies have carried this kuleana through ceremony, through protocol, and through the ike of kahu, who have faithfully served us at Mauna Ala. We come with lived experiences. We have seen what happens when there is no clear process or policy in place, particularly in the selection of the curator of Mauna Ala, where key voices, including the Royal Societies, the Association of Hawaiian Civic Clubs, the lineal descendants, are not meaningfully consulted. That cannot continue. This measure gives us an important opportunity to work in partnership with the state to ensure that the stewardship of Mauna Ala is done properly, grounded in cultural protocol, guided by ike, and inclusive of all those with kuleana. Mauna Ala is a sacred resting place of our ali'i. It deserves a process and a structure that reflects that truth. So mahalo nui loa for this opportunity again to share our mana'o.
Thank you, Ms. Khan. Appreciate you being here. Next, former colleague of mine, Quentin Kwananakoa.
Hello.
Welcome, Representative.
Thank you.
Good to have you back again in the building.
Back in the house. I say good evening, Chairman Tarnas, Vice Chair Poipoi, members of the committee. You know, I am glad to be here and to speak after Leimomi because she kind of summarized everything real clear, real straight. So I have just a couple comments. One, I'm representing, my name is Quentin Kuhio Kawananakoa. I'm representing the House of Kawananakoa. And I'm simply wanted to note that we do agree with all the responsibilities that have been laid out in the House Draft 1. It seems to be winnowed it down to something that made sense that we can probably accomplish by the working group. And the other item that I've noticed, the last item, was that there's a catch-all clause that simply affords us the opportunity to take up other issues that may arise that we haven't thought about here at this point. And if we can bring other suggestions and recommendations to the legislature, we'd love to do that in the following sessions. I also wanted to note the composition of the working group committee, and to answer perhaps as a suggestion to the AG's question, all of these are groups for the most, they are all groups for that matter, and so they have their internal processes for otherwise nominating or sending a representative on behalf of their group. So we would be sending a representatives to this to the working group to otherwise make decisions and to add discussion and proffer the questions that you folks have given to us, or anticipating to give to us. With that, I just wanted to recognize that we appreciate your long work here this evening, and that and also the real concern that you folks have shared in trying to amend this bill. Because I'll be the first to admit, it had flaws in the beginning. I mean, it really was extensive. Some of the wording wasn't correct, but it was a matter of us rushing to the legislature to get something in. And without your help in amending those concerns, we wouldn't be here today. But I think the bill is strong now, it can move forward, and we look forward to your release today.
Thank you, Mr. Kawananakoa. Good to see you again, sir. Next, Colleen Ayu.
Aloha, I'm Colleen Ayu, Kuhinanui of the Daughters and Sons of the Hawaiian Warriors Mamakakoa, and we stand in opposition of Senate Bill 3247, Senate Draft 1, House Draft 1, to establish a temporary working group within DLNR with 7 voting members. It's really important because the controversy over the DLNR hire in 2024 is really the actual input of why this bill is being established. In 2024, DLNR's selection panel did not follow the traditional and proven process that was used when hiring the current curator to fill the vacancy left by Kai Mai'oho. And we have left for you a brief history of that pilikia in your folders. Before any new legislation, that's the one.
Everyone's got a copy of the packet.
Thank you, everyone, because our group took time to get that to you so that you would be able to find it readily. And before any new legislation or amendments to the Hawaii revised statutes that are existing take place according or affecting Mauna Ala, really what we're talking about is the honored and sanctified position of the kahu must be restored. Traditionally, kahu were knowledgeable, accountable, and committed to the sanctity of Mauna Ala. As a result of DLNR's delay in addressing the at-will position, Mamakakoa has been denied access to Mauna Ala on 2 occasions. Mamakakoa believes that the Hawaii Supreme Court, Kapa'akai Hoka'aina, versus Land Use Commission should be considered. Mamakakoa is strongly opposed to this bill, and we ask that you review our entire testimony from 2024, 2025, February 2026, March 2026, and today. And we ask that you consider our ongoing request not to move this bill forward. Let us solve the very first problem, which is the revetting and the hiring of the current curator in 2024. Mahalo.
Mahalo. Appreciate you providing your testimony. Navahini Lanzalati.
Aloha kako, Chair Tarnas, Vice Chair Poipoi, and the members of the presiding committee. My name is Navahine Lanzalati. I'm here today on behalf of the Ahahui Ka'iolani, and we stand on our written testimony in strong opposition to SB 3247, Senate Draft 1, House Draft 1. Ahahui Ka'iolani honors the Princess Ka'iolani, the heir apparent at the time of the overthrow, and we are a Hawaiian organization and been consistently participating at Mauna Ala for the 50 years of our organization's history since Princess Ka'iolani's 100th birthday. I apologize, I'm not in the customary Ahahui attire today. I had to come straight from work. But I am here today to reiterate our position that this bill, even as amended, does not, it delays the resolution of this original conflict of the DLNR selection process of the kahu, demonstrates legislative overreach, denies Hawaiian customary practice, and also still lacks the necessary processes that are really necessary to responsibly implement the work that it sets forth. So we just ask that the committee consider these oppositions and vote against moving forward this bill and allow those who are traditionally responsible for taking care and stewarding Mauna Ala to move forward with the resolution of this Pilikia. Mahalo.
Mahalo. Anyone else wishing to testify on this measure? Yes, please, come on up and introduce yourself.
Thank you, Chair. My name is James Maioho. I'm representing the descendants of Ho'olulu. And I read, all the testimony through this process. My family has been, working on this or some sort of form of legislation or correction for the last, 3 years almost. And there's a couple things I want to address. But first, I want to commend all you folks and all the legislators that have really put in effort this time around. This is really the best solution that I've seen over the last few years for getting some sort of working, acceptable process or body to manage Mauna Ala. Mauna Ala is very unique, not only within the land laws and within the inventory and management of the state, but within our culture. And it deserves its own, and I would advocate for a fully empowered commission of a proper size to look at the operations and things. The operations of Mauna Ala are really pretty straightforward and simple. Its operating budget is a rounding error in the Parks Department's budget. The process that has traditionally been for generations in place of picking a kahu, as Auntie addresses, was very straightforward. The family identifies from the bloodline. The community, the Royal Societies, the Hui affirms that, or not affirms or argues about it, and then the state supports that. The DLNR, it had migrated to that department. It was just a place to park the budget. It started out in public works. Really just to put the minor things through the major endeavors there are done through an agreement between the trust and, like PK said, with the DLNR that has worked very successfully since 2013. And I believe if we properly empower and have the right number of people on the board, that a lot of the cultural issues and debates can be solved by the Kanaka Hawaiians within this body. With some guidance and definition from you folks. One clear definition, I think, that would take a lot of the controversy off the table is if you define and protect the Kuleana and the bloodline and the family that's associated with. If that's defined, then we just have to talk about process and protocols and how everybody gets to interact with each other there. I do think it's important that some other voices are included. OHA has reached out to me, and I know they want to be included. The DLNR has some very, very knowledgeable people that historically know all the projects that have happened there. My thought on that is that if you have what I would define as the stakeholders being the core voting members of an empowered commission, and then as part of that commission, because they're government and not cultural Kanakas, be part of that, but be non-voting members, like the DLNR and like OHA, to be included in the conversation because there are assets and historical knowledge and data there that would be useful. But because they're already a state entity and not a cultural group or a stakeholder, they don't pull permits or put in money, to be included in it, but not have a vote. That should be left to the Hawaiians. But otherwise, I really commend the work that's going through. I believe it's a very positive step, and I believe it gives us a lot of opportunity as a community to come together and work through this issue and prove that we can, and as a group, go on to other things that are important to us as well. All right, mahalo.
Mahalo. If you would be so kind as to provide your name and organization with Kamana over there, it'd be great. Thank you. Anyone else wishing to testify on this measure? If not, questions, members?
Question, Chair.
Yes, Rep. Garcia.
Mr. Kononoko. Hi. Thank you for being here, and it's nice that your middle name Kohil is there, and especially tomorrow's Kohil Day. My question is, I've heard from a few people from the state side and from certain organizations the issue with having a 7-member group. What is your take on that? Are you open to more, less? I mean, it seems like there's issues with just 7.
One of the great saving aspects of this legislation is that the sunshine laws, I guess it's chapter 1 or section 1, wouldn't apply. So we have an opportunity to really have open conversation with many people to come forward. And I think it's the vision of this working group, maybe perhaps a commission, that would take in all this information and then vote accordingly. And the best people to vote, as was also just mentioned by James, is that, you know, we have these groups that have been long-standing for many, many, many years, decades, have been part of the stakeholders at Mauna Ala. They know the ins and outs of it. It's always best to get new mana'o, different views, different perspectives from the community. But in the end, they can help discern what is the most important things to include with regard to taking a look at cultural practices, different protocols to be observed at Mauna Ala. So we could go on all those details, but the reality is, I actually offered a 7th. I offered 2 different amounts, 12 or 14 of all the people who would be very good candidates to be members and voting members. And I also agree with the comments of having non-voting members for the state and OHA for DLNR, because very valuable, but best to leave the Kanaka Maoli to decide on the cultural, spiritual concerns. I should note that I did speak with the DLNR, and they noted how they're very difficult to make these cultural decisions and protocols and set them in place. They're very good at maintaining the grounds, the facilities. So with that in mind, I did try to collapse perhaps the Ali'i Trust into 1 vote, collapse the Royal Societies into 1 vote, and then you have your lineal descendants, and then you have 2 others would be maybe daughters and daughters of Hawaii, and then also perhaps OHA, and maybe not necessarily. That was just an option. I just didn't want to come to this committee with no way, can't live with 7. I think we could by managing ourselves. So we are flexible. I tend to agree with the larger number. It's clear, it's more forward. We understand each of those organizations have their own mana'o, and they can bring that to the table and then vote accordingly. So that would be my response.
Thank you very much. Thank you, Chair.
Okay. Any other questions? If not, I don't wanna lose quorum, and we are gonna lose it soon. I'd like to finish up and get to voting on it. Do you have a? Rep. Shimizu, go ahead.
Yes.
Would you consider being part of where you are?
When we talk about, when I talk about opposing the bill, it's in its entirety. Because when you set a number of people to be on it, you have to consider what qualifications do they bring besides being Hawaiian and a Hawaiian organization. And the sharing of information is very important. As a plastic surgeon wouldn't bring necessarily someone who affixes bones into a conversation. You know, how we consider this is there are many things that are private to Hawaiian traditions and customs. They are private. They are not secret. And part of it is because they are handed down, not only through legacy, meaning blood, but also lineage, training, and knowledge. It's very important that we understand genealogy and lineage, cultural responsibility, ike, mana'o, and hohonu. These are all terms that not all Hawaiian groups understand. And for me, I would feel uncomfortable sharing information that has been given to me, not in secret, but in trust that I would keep with people I don't know. I have no idea what their background is from, but I am mandated to share and kuka and to discuss and then record everything that's being said. Not even in our own homes do we allow people in to record conversations between husbands and wives and parents and children. So for me and your question, would I consider being in this working group? I oppose the whole situation of a working group.
Thank you.
I do promote the idea of speaking amongst ourselves one-to-one when we are carrying that ike that requires truthful conversation. We say alo ke alo, which means to be in the presence of the one you're speaking with, which is a very Hawaiian thing, because as they study body language, so do we Hawaiians interact with each other. And when we talk about sharing, it is really a sharing that I know I share with you. It doesn't go beyond this room. It's what you and I have shared. And in hopes that when we are called upon, we will act with the best interests, the best knowledge, and most importantly, the ho'ihi and respect of our kupuna and our ali'i who are buried there. And that is my question. My answer to your question. I'm sorry.
No, that's fine. Thank you very much.
Thank you.
Okay, thank you very much for all the testifiers. And we're gonna move on because we really are running out of time and I don't wanna lose quorum. Senate Bill 2363, House Draft 1 related to counties, authorizes the counties to close public lands when necessary to protect public health, ensure public safety, or preserve natural and cultural resources. Department of Land and Natural Resources. Not present. Next, Office of Hawaiian Affairs.
Lealoha Makuanani on behalf of the Office of Hawaiian Affairs. We'll largely stand on our written comments, but I want to highlight here that we are asking for consultation in the process of a closure with Native Hawaiian organizations. And in the last committee, I think there was a little confusion, so I'd like to clarify that that's not in emergency situations. We're just asking for that consultation where traditional customary practices may be an issue, but also on the hand where it includes natural and cultural resource preservation closures, that there's a lot of traditional ike that can be provided by Native Hawaiian organizations to also help inform on those types of closures as well. So our language, the practical part is an attempt to say not in emergencies, but we're open to amendments or adjustments to that language just to ensure that it's clearly understood, not in emergencies.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions? Let's move on to the last measure then. Senate Bill 2372, Senate Draft 2, House Draft 1 relating to trees. This establishes base selection criteria for designating exceptional trees. It does other things, but I'll leave it at that. We have Department of Taxation.
Good afternoon, Chair, Vice Chair, members of the committee. Clinton Piper, Department of Taxation. I would just point that we are largely agnostic to the contents of this. Our sole contribution to an earlier draft was the insertion of section 3, just so that the thrust of this bill does not inadvertently affect the exceptional tree deduction under Chapter 235. Thank you.
Understood. Okay, next we have Department of Land and Natural Resources. And finally, the Outdoor Circle. Oh, are you Department of Land and Natural Resources on Zoom? Okay, go ahead, DLNR, and then I'll come to you next. Go ahead, DLNR. Please proceed.
Thank you. Yes, thank you. Heather McMillan, Department of Land and Natural Resources. We stand on our written testimony and support. I'm available for questions. Thank you.
Thank you very much, Ms. McMillan. Next, the Outdoor Circle.
Aloha, I'm Winston Welch, Executive Director of the Outer Circle, and we strongly support this bill, which modernizes Hawaii's Exceptional Tree Program for the first time in over 50 years, with science-based criteria that are updating our guide for designation and stewardship. It also creates a significant tree category, which is a practical pathway for future exceptional trees while strengthening our long-term canopy resilience. Equally important, we do improve coordination by establishing a statewide arborist advisory committee to work along the county committees to share expertise and consistency. This is a thoughtful, non-controversial update with broad support, and we do urge you to pass it. Thank you very much.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions? Okay, let's.
Question for DLNR.
Is it necessary really? Because we're gonna lose quorum.
Okay, let's pass the question.
Yeah, because we do want to move this bill out, and so I think.
Sure.
Yeah. Okay.
Stand, Chair.
Thank you. Appreciate your forbearance. Okay, let's move to the top of the agenda for decision making. Senate Bill 3219, House Draft 1, proposing amendments to Article 7, Section 12 and 13 Hawaii State Constitution. On this measure, I just would like to make technical amendments and move it along. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3219 HD1 with amendments. Chair and Vice Chair vote aye. Representative Bellotti is excused. Representative Hashem is excused. Representative Kahaloa.
Aye.
Representative Sayama, excused. Representative Takayama.
Aye.
Representative Cochran, excused. Representative Garcia,
Reservations.
reservations. Representative Shimizu. Recommendation is adopted.
Thank you. Senate Bill 2054, Senate Draft 2, House Draft 1, relating to public safety. I would like to just make one modification on it. Page 3, lines 7 to 8. We're just gonna make sure the notice is provided to the administrator of IEMA, since that's the same person as the Adjutant General. We don't need to send it to both of them. So we'll just make sure the notice is provided to the administrator of IEMA. That's the only change I wanna make. Any questions or concerns? If, yes.
I understand the reason for this, but I think it's alleviate fear and confusion with their. I'm gonna be voting on this.
Okay.
Chair.
Yep.
Similar concerns. I also want to note the opposition testimony from the Department of Defense. And I just feel that this bill is another political bill this session to target the federal administration, so no vote.
Understood. Any other comments? If not, Vice Chair for the vote.
Voting on SB 2054 SD2 HD1 with amendments, noting that Representatives Bellotti, Cochran, Hashem, and Sayama are excused. Are there any voting no in addition to Reps Garcia and Shimizu? Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2688, Senate Draft 1, relating to compassionate release. I think, as you heard from the testimony, House Bill 1628, House Draft 2 is a preferred language. I recommend we insert the language of House Bill 1628, House Draft 2, into this measure and move it forward. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2688 SD1 with amendments, Representatives Bellotti, Cochran, Hashem, Sayama are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2575, Senate Draft 2, relating to firearms. I recognize why this was put forward. I want to move the measure forward, but I want to modify it so that the penalties are not as harsh. I think there's frustration with how the judges are sentencing some of these offenders, and it's not as harsh a sentence as you want it, but the law provides the judges the ability to do that. But the prosecutors don't, either the prosecutors don't ask for it or the judges don't give that sentence. And so people who are frustrated with that come to the legislature and say, please increase the penalties, increase the sentences, make it from a misdemeanor to a Class A felony or and this is not just this, but it happens regularly. And personally, I want to maintain judicial discretion, but I will acknowledge that there is strong support for increasing penalties, so here's what I'm going to suggest. I'd like to move this forward with House Draft 1, and here's my recommendations. On page 1, lines 3 to page 1, line 17, remove that section, because I don't think mandatory minimums are a good idea. That's my suggestion. I want to amend page 3, line 13 to change the felony classification from Class A felony to a Class C felony, so it still would be changing it to a felony. Amend page 3, line 21, so that a violation of subsection B is a Class B felony, and reinsert the language, quote, and if said prior felony conviction is that of a crime of violence as defined in section 134-1, the defendant shall be sentenced to an indeterminate term of imprisonment as provided by law, end quote. Amend page 5, lines 10 to 12, so that the violations of subsection B1 and B2 are Class B felonies. Defect the effective date to July 1st, 3000, and make technical amendments for clarity, consistency, and style. Questions or concerns, members? Rep. Garcia.
Thank you, Chair. I like the bill. I'm definitely weary of. I just feel that this legislature seems to be in the business of protecting criminals and trying to pass laws on firearms against law-abiding citizens. I liked the bill originally and I disagree with your amendments, but I will vote yes to keep the bill moving, so, yeah, that's it.
Appreciate it. When you get to be chair of judiciary, you could do things differently.
Republicans take over, we will.
Okay, I'll leave that to you. Any other comments or concerns?
Similar to
Okay.
I support the police officers and for sure. I would want to respect that, but I move whatever we can forward.
Thank you.
And hopefully we'll live for another day and get improvements on the next committee.
Yeah, and it does go to another committee. And then if it moves out of the next committee, it moves to conference, so we'd have the two versions, Senate version, House version, then we go to conference committee and negotiate between the two, so that's how it works. Okay, if there's no more comments or concerns, Vice Chair for the vote.
Voting on SB 2575 SD2 with amendments. Representative Bellotti is present. Representatives Cochran, Hashem, and Sayama are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Did you have you had reservations?
No, I'm voting yes.
Yes, no reservations, okay.
Yeah.
All right, just making sure we got it, so it's
Thank you,
straight
Chair.
up.
Thank you.
Okay, thank you. Next, Senate Bill 2239 relating to voter registration. On this one, I'd like to move it out with technical amendments for clarity, consistency, and style. Defect the effective date to July 1st, 3000, and adopt the recommended amendment from the Attorney General. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2239 SD1 with amendments. Representatives Cochran, Hashem, and Sayama are excused. Are there any voting no?
No vote.
No for Representative Garcia. Any with reservations?
I'm sorry, Chair, you included the Attorney General's affirmative
Yes.
of the citizenship, right?
Yes.
Okay, thank you. I'll vote with reservations.
Reservations for Rep. Shimizu. Recommendation is adopted.
Thank you. Senate Bill 2601, Senate Draft 2 relating to procurement. On this measure, I'd like to move it out of the House draft with technical amendments for clarity, consistency, and style. I'd like to adopt the recommended amendments from the State Procurement Office. And also defect the effective date to July 1st, 3000. And I want to make it clear that so that on page 4, line 5 to 10, if the awarded contract amount exceeds 15% of the amount of the available appropriation or balance of an appropriation, the contract shall not become binding for the purposes of this section unless approved by the Chief Procurement Officer. I think that clarifies that better. Those are my recommendations. Questions or concerns, members?
Chair, I really don't see the purpose of this bill, but I will vote with reservations.
Understood. Any other comments? If not, Vice Chair for the vote.
Voting on SB 2601 SD2 with amendments. Representatives Cochran, Hashem, and Sayama are excused. Are there any voting no? I have reservations for Rep. Shimizu. Any additional reservations?
Reservations.
Reservations for Rep. Garcia. Recommendation is adopted.
Thank you. Senate Bill 1166, Senate Draft 2, House Draft 1 relating to insurance. I've got a number of different amendments I want to make. Page 1, line 5. I'm passing out to you the amendments. It's a combination of the Polluters Pay Hawaii recommendations from our House Majority Staff Office. So on page 1, line 5, add, quote, climate disasters threaten the functionality of the regular insurance market and the residual market or insurers of last resort like the Hawaii Property Insurance Association, as well as taxpayer resources in the state-funded Hawaii Hurricane Relief Fund, which was reactivated by Act 296, Session Laws of Hawaii 2025, to provide insurance coverage in scenarios where the private market fails to do so. Page 2, line 14, add, quote, the legislature believes that access to affordable insurance is necessary for the stability and financial health of residents of the state, but is threatened by increasing non-renewal rates and rapidly rising premiums. Therefore, the legislature further believes there is a compelling state interest in preserving insurance market stability, essential coverage for property owners and lenders, and affordable housing for the state's residents. Page 9, line 3, amended to include the Hawaii Hurricane Relief Fund and page 9, line 19, add, quote, including the Hawaii Property Insurance Association and the Hawaii Hurricane Relief Fund, end quote. Page 10, line 9, add Hawaii Hurricane Relief Fund. Page 12, lines 6 to 13, revise subsection D to read, the payment by a plaintiff to a policyholder for qualifying damages resulting from a climate disaster or extreme weather or other event attributable to climate change, including an occurrence whose likelihood or severity was increased by long-term changes in the climate system, shall be deemed an injury, in fact, to the plaintiff for purposes of standing under this section. Page 14 strikes line 14 to 19. Page 15, line 5, add, quote, in any civil action against a responsible party under this section, the Hawaii Property Insurance Association, Hawaii Hurricane Relief Fund, or any private insurer may recover or obtain court costs, litigation expenses, reasonable attorney's fees, and any other relief that the court or a jury deems proper. Page 19, line 16, add Hawaii Hurricane Relief Fund, and finally, technical amendments for clarity, consistency, and style. Those are my recommendations. Questions or concerns, members?
Comment, Chair.
Yes.
Thank you. I just think that this bill is bad policy and that eventually it will raise the cost of energy for Hawaii residents, so no vote.
Understood. Any other comments? Okay. No other comments? Vice Chair for the vote? Yes.
Voting on SB 1166 SD2 HD1 with amendments, Representatives Cochran, Hashem, and Sayama are excused. I have no votes for Reps Garcia and Shimizu. Any additional no votes? Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 3247. My recommendations are to replace the language of this bill with the language from the original bill language, SB 3247, which establishes a commission rather than a working group, and amend the inserted language as follows. Amend the membership to 9 members as follows. 1 member who is a representative from the group of Ali'i Trust known as Malama Mauna Alahui. 1 member who is a representative from the Royal Order of Kamehameha I. 1 member who is a representative from Ahahui Ka'ahumanu. 1 member who is a representative from the Daughters and Sons of Hawaiian Warriors Mama Kakawa. 1 member who is a representative of Hale o na Ali'i o Hawaii. 1 member who is a lineal descendant representative of those interred at Mauna Ala connected to the Kamehameha dynasty. 1 member who is a lineal descendant representative of those interred at Mauna Ala connected to the Kalakaua dynasty. And 1 member who is a lineal descendant of High Chief Ho'olulu and a member of the Ho'olulu Kahu family. The chairperson of the Department of Land and Natural Resources or their designee, provided that this member shall be a non-voting ex officio member and may not serve as the chairperson of the commission. I'd like to remove section D, which is the language relating to hiring an executive director, and amend section E to read, the legislature may appropriate funds to support the operations of the commission, including maintenance and cultural programming. The commission may also receive private or federal funds to further its objectives. And between F and G, add a new section that reads, the kahu of Mauna Ala shall be recognized as the individual responsible for the cultural, traditional, and spiritual care of the iwi kupuna interred at Mauna Ala. We will defect the effective date to July 1st, 3000. Questions or concerns, members?
Chair,
Yes.
I'm gonna be voting with reservations. I totally like this bill, but just out of respect for Colleen Ayu and her Manao, I just wanna
Understood.
respect that.
Very good. Any other comments? Yes.
Thank you, Chair.
Vice Chair.
Just really quickly, just for the members of the public, I just wanna assure everyone that there's still time for conversations to be had, to continue to work on this bill, and that we're committed to continuing to work on it as it goes through the process.
I echo that. We're still in process. We're getting closer, but we're still in process. And I wanna acknowledge the work that the Vice Chair and Representative Kahaloa has put into this measure, and I'd like to move it forward. Okay, any other questions or comments?
Chair and Vice Chair, thank you for your work on this and for keeping the conversation moving. I don't know if we're fully there yet, but it's a work in progress and we're trying to listen to the voices of our Hawaiian leaders and our kupuna and try to, hui everyone together and make the right decision on this. But it takes time.
It does.
And we appreciate the public comment on this.
Yeah, absolutely. And it's with great humility that I acknowledge the work of Representative Poipoi and Representative Kahaloa, who have really helped with this. Any other comments? Otherwise, we'll take it to a vote. Vice Chair for the vote.
Voting on SB 3247 SD1 HD1 with amendments, Representatives Cochran, Hashem, Sayama are excused. Are there any voting no? Any with reservations and Rep. Shimizu with reservations, any additional reservations? Recommendation is adopted.
Thank you. Senate Bill 2363, House Draft 1, relating to counties. I'd like to adopt the recommended amendments from the Office of Hawaiian Affairs. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2363 HD1
Yep.
with amendments. Representatives Cochran, Hashem, Sayama are excused. Are there any voting no?
No vote.
No for Rep. Garcia. Any with reservations? Recommendation is adopted.
Thank you. Last measure, Senate Bill 2372, Senate Draft 2, House Draft 1, relating to trees. I'd like to adopt the recommended amendment from the Kauai County Office of Boards and Commission and make technical amendments for clarity, consistency, and style. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2372 SD2 HD1 with amendments. Representatives Cochran, Hashem, Sayama are excused. Are there any voting no?
No vote.
No for Rep. Garcia. Any with
I'll take
no for Rep. Shimizu. Any with reservations? Recommendation is adopted.
Thank you. There being no further business before us today, we are adjourned.